From the supplementary list, under heading for orders with effect, item 1, WPS 6347 of 2023.
The counsel for the petitioner is present. WPS number 6347 of 23 with IA number 2734 of 21. The learned counsel for the petitioner submits that interrogatory application has been filed for withdrawal of the present petition. She submits that during the pendency of this case, the matter has become infructuous. Counsel for the respondents has no objection to the prayer for withdrawal. Accordingly, this writ petition is dismissed as withdrawn. IA number suggests is closed. I will not give you any liberty. Next.
Under heading for fresh filing, item 2, WPS 7160 of 2023.
Stating therein that even after being disqualified in the interview, their work is being taken by the respondents on the as sweepers. That is been filed, supplementary affidavit has been filed. A specific statement has been made by with regard to.
Two of them are not working.
Yes.
Two of them are not working.
So, because after filing this.
Now you tell us that if you are continuing to work, you are working as casual employee only, right? Is there any against which post you will be regularized? And do you satisfy the criteria for regularization? Since when, under which provision of law you will be regularized?
For 7 years, we are
7 years is sufficient as per the circular.
No, I'm not saying this.
Then
thereafter, my lord, examination was held. For working as sweepers, my lord, only.
You are working. It's okay. We understand
there is
that.
never any complaint or anything.
No, maybe.
For the previous day,
you see, the question, that's right, we asked you, and then, you see, in your writ petition, you said.
But two persons are still getting, my lord. They are working.
No, even if they are working, that will not create any right in your favor for regularization. There is no question of any regularization of your services.
But my lord, when they are working, there is some posts are also vacant.
No, you cannot be regularized. Where is the scheme for regularization of your services?
My lord,
is there any scheme for regularization of your services?
There is no scheme, but in the examination, they have appeared, they were
unsuccessful.
Definitely, my lord. I don't say unsuccessful, but my prayer is only that after, if any post falls vacant
we
or
will not,
anything,
no.
that may be considered.
No. Nothing. No observation can be made in that
asked by your lordship, my lord, I filed the supplementary affidavit, my lord.
That's right, because I wanted to know whether you are working or not. Yes. And you have disclosed it in the supplementary affidavit for the first time that you were declared unsuccessful.
No, I have stated. In my writ petition, I have stated.
No, your statement is not very clear.
I have stated that this cannot be. I have stated this is my answer. When we are working.
You have just a second. You have simply stated that petitioner has not been declared qualified. In the select list, his name is not mentioned.
No, not disqualified. Therefore, disqualified.
So, therefore, once you have been disqualified, then what is your right to continue?
But, my lord, it appears that there is necessity of some sweepers, my lord. The post are still
maybe vacant, they have right to appoint you. You show me some scheme for regularization, I will consider you.
My lord, it may be considered on the ground that if any vacancy falls vacant,
it can't be. It just can't be. It just can't be.
Of promotion of the other employees or a deployment may be made under such circumstances. Therefore, I was paying your lordship, my lord.
No.
For the previous day, my lord,
I've seen it.
Ask me, I have filed, my lord, and
very good, you have filed it.
Very specifically, I have stated, my lord, that in spite of my lord that being disqualified on 16/11/2023, thereafter again, I am, my lord, payment has been made till, my lord, March 2024. After getting permission from the learned principal judge, family court, principal judge, district and principal judge, my lord, of the concerned district, my lord. So when this statement has been made, my lord, and there is necessity of the employees, my lord.
Case number 7160 of 2023. For the learned counsel for the petitioner, nobody appears on behalf of the respondents. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that a supplementary affidavit has been filed in the present case. Indicating that the petitioner number, with regard to the present status of the petitioners, he submits that in spite of the fact that the petitioners were disqualified in the selection process,
There is one observation we made, my lord. They may not be, even if, my lord, by this order, one thing may be considered, my lord. By this order, they may not be turned down, my lord.
they will be turned down, because why this court is
They
taking
be allowed to
work,
continue, my lord.
then you have to withdraw. We don't want to. We will just simply say that no order can be passed, and it is not clear that in spite of filling up the vacancies, how and under what circumstances they are being continued. At least that observation has to be there.
Dispose of कर दिया जाए बोले, because
कुछ
they will
नहीं।
be turned down, my lord.
नहीं
Because
आपको
it's a difficult
they
thing.
will be turned down. I am telling you, they will be turned down.
Therefore,
Therefore you withdraw if you want to.
I have
No instructions. Right.
some time may be given.
No time.
I will seek instruction.
No.
It may be disposed of, my lord.
No.
To consider if any post falls vacant or anything like this.
आपका जब आर्गुमेंट खत्म हो जाए तब आप हमको बता दीजिए. You cannot force an or
No,
force.
I cannot force, but I'm praying
No,
because my
you
lord
have
will
not
be
shown any right in your favor.
but
Show me
they-
some right, I will give you the sky. You just
My
tell
lord, I am
us.
afraid because of only reason that by this order they may not be turned down.
They
If
will be turned down because it appears that the persons who have been inducted, they are not working. The persons who have been inducted, they are not working.
No, they are working, my lord.
Then we do not know.
But my lord,
We do not.
only because of this, my lord, I am making this clear, my lord. They will be turned down. Therefore, my lord, such compassionate view may be taken, my lord. So that they may
अब
not
आप
be
प्लीज
turned.
बैठ जाइए. प्लीज बैठ जाइए. कुछ मत बोलिए. Please don't speak a word when I dictate the order. I've heard you. You sit down. The learned counsel for the petitioners has submitted that the petitioners had participated in the ऐसे लिखिए. The learned counsel for the petitioners has submitted that the petitioners were petitioners are employed on daily wage basis under the respondent number 2 and 3 which is apparent from Annexure 1 at page number 32 dated 17/2/2017, and they had participated in the selection process pursuant to advertisement number 1 of 2023 but were disqualified after interview on 16/11/2023. The learned counsel submits that in spite of having disqualified, in spite of aforesaid fact, the petitioner, the respondents number 2 and 3 have continued to take work from the petitioners, which indicates that there is still requirement of the petitioners in the establishment of the respondent number 2 and 3. The learned counsel submits that under such circumstances, the petitioners are entitled for regularization. However, during the course of arguments, the learned counsel for the petitioners has not been able to refer to any scheme for regularization on the basis of which the petitioners could be regularized.
My lord, one period may be fine. My lord, give me permission.
After hearing the learned counsel for the petitioners, it appears that the petitioners were employed on daily wage basis and were being paid remuneration accordingly. While they were still working, the sanctioned vacant posts were advertised to be filled up, in which the petitioners participated. The advertisement was advertised by the advertisement number 1 of 23, in which the petitioners participated. And ultimately, after an interview, they were disqualified. It further appears that at the time of filing of the writ petition, the petitioners continued to work on daily wage basis. But during the pendency of this writ petition, the petitioner number 3 was discontinued. Petitioner number 3 and 4 were discontinued. The last payment, which was made, that should be sufficient. Considering the facts and circumstances of this case, and the fact that the petitioners had participated in the selection process and were declared disqualified, and also the fact that no scheme for regularization has been placed on record, so as to entitle the petitioner for the relief as prayed for in this writ petition. This court is of the considered view that merely because the respondents respondent number 2 and 3 had taken some work from the petitioner even on daily wage basis, even after they were declared unsuccessful. The same by itself is not sufficient to grant the relief as prayed for by the petitioners in this writ petition. Accordingly, this writ petition is hereby dismissed. You are for the state. Counsel for the state is present.
Item 4, WPS 2131 of 2023.
Yes, petitioner.
The petitioner has been working for more than 10 years, so that's why we are paying for regularization of his service and also giving conservation benefits.
Since when have you been working?
1985.
1985
Yeah.
to
2004.
2004. How can you claim regularization in 2023?
So now he's been applying, he's been petitioning claim for regularization since then.
Thank you.
But it has been declared.
WPS number 2131 of 2023. The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner has worked for a period from 1985 to 2004, and therefore the petitioner is entitled for regularization. The total period of work exceeds 10 years. She submits that in view of the aforesaid facts and circumstances, the impugned order dated 31/1/2022 calls for interference It has been also submitted that the impugned order has been passed pursuant to order passed by this court in WPS number 396 of 2017. Learned counsel for the, are you opposing?
Yes, ma'am.
The learned counsel for the respondents has opposed the prayer of the petitioner. After hearing the learned counsel for the petitioner and upon going through the impugned order, this court finds that as per the impugned order, the petitioner discontinued to work after August 2004. And in spite of repeated communications to the petitioner, he did not join his duty. In view of the aforesaid facts and circumstances, this court is of the considered view that the petitioner is not entitled for regularization in terms of the scheme for regularization and also the judgments passed by the Honorable Supreme Court as referred to in the impugn order. This court further finds from the impugn order that the payment has already been made to the petitioner for the period he had worked. This court finds that the impugn order is a well-reasoned order which does not call for any interference. Accordingly, this petition is hereby dismissed.
Item 5, WPS 2345 of 2023.
Just a moment. You are for JPSC?
JPSC.
What is the cutoff marks?
Cutoff
And
BC1 cutoff is 429 and she has obtained 420 marks.
you come to your page number 20.
Counter-affidavit.
Yes. Page 20.
Gotcha.
You have for unreserved category, you have male and female. What about this male and female category in other
The
categories?
cutoff marks for mains written examination. It is only in relation to the mains examination where we have distinguished for the male and female.
Okay.
So the cutoff mark for final selection was there, it is equivalent to each. So cutoff marks for BC1 category is 429. There is no distinction. Rather, your lordship may come to the conclusion why she was not first recommended. In the result itself, they have also mentioned that she had submitted a caste certificate of BC1 which was in central government format. Thereafter, she submitted an application.
No,
So
that is totally
please
different.
consider
Your-
as
we are only considering the ground
yes, sir.
that she has received less marks than the
Less
last.
than the cutoff marks. Yes. The last selected candidate.
All right, it's passed over.
Lordship.
Let the council come. At 12 o'clock.
From the daily list, under heading for final disposal, item 1, WPL 2777 of 2019.
At the outset, my apologies. We had 5 requisites and we had received the memo as well by 16th of March. We were unable to serve it. Just 10 days time, we will serve it as well as file the affidavit in the meantime.
So the date which must be mentioned in the notice has expired.
Yes, Your Ladyship,
So,
that was that.
How will it serve the
We
purpose?
will return it, Your Ladyship, and ask them to issue a new one as well, Your Ladyship. Only 10 days time I'm paying, Your Ladyship. We had received the requisites. It is our fault that we didn't, we couldn't serve the notice personally to them. We filed the requisites, received it by 16th.
WPL number 2777 of 2017. Learned Counsel for the petitioner submits that although the requisites were received by the counsel for the petitioner, but no steps could be taken for personal service in terms of order dated 11/3/2024, and accordingly the supplementary affidavit regarding service of notice could not be filed, has not been filed. The learned counsel submits that another date may be fixed, so that in the meantime the order dated 11/3/24 be complied. She also submits that registry be directed to change the date mentioned in the notice accordingly. Considering the submissions, let the notice in terms of order dated 11/3/2024 be served upon the respondent. The supplementary affidavit regarding service of notice be filed by April 24. Office is directed to make necessary changes in the notice which has been handed over to the petitioner, counsel for the petitioner for appropriate for service on for personal service. That's it. Date is fixed already.
22nd.
But by 22nd, no. The supplementary affidavit regarding service of notice be filed by 22nd. Post this case on 24th April.
Item 2, WPS 393 of 2023 along with item 3.
Pursuant to my lord's order dated 12/3/24, in the supplementary affidavit, though we have prepared the program file, only praying for 1 week time.
You don't.
Supplementary affidavit as well as list of dates and events all have been prepared.
File it. Show it to us. File it right away. File it. If it has been prepared, file it, please. Give it to us. And you argue your case. You have prepared your list of dates, everything. Let us see. In both the cases,
Well,
where is the gradation list?
it is not a case for gradation.
You have filed your supplementary affidavit?
It is filed not, but record does not show, perhaps not.
When did you file it?
On 19th, affidavit,
दिखा is at 19.
नहीं दिखा रहा है, इसीलिए हम बोले कि लगता है कि वो फाइल नहीं हो पाया है, तो कहीं मिसप्लेस हो गया है। मेरा ऑफिस रिकॉर्ड में वो ऑफिस कॉपी रखा हुआ है, लेकिन वो रिकॉर्ड का भी जस्ट चेक किए तो नहीं दिखा रहा है।
But I think the same is
Copy
already
is
in the
also
counter
filed.
affidavit. Edition.
Sorry?
The same is already in the counter affidavit.
In next case, the counter affidavit, that rule is already there. My lord's direction was to bring on record the guiding effect, the rule for promotion.
But if you have not filed it, how do we take care?
वही जो इतनी डिफिकल्टी
सिर्फ रूल ही लाए हैं, कुछ और भी है?
केवल रूल ही, my lord का ऑर्डर केवल रूल था।
हाँ ठीक है, रूल ऐसे ही देख लेते हैं, सप्लीमेंट्री का कैसे होगा? चलिए आगे
Prayer of the petitioner, जो पहले रूल को प्लेस कर दें।
प्लेस कर दीजिए।
नहीं। The rule या नियमावली बिहार राज्य प्रारंभिक
पूरा पढ़ने की जरूरत नहीं, खाली रेलेवेंट पोर्शन
the relevant portion will not the rule 4 will not I have highlighted that part. This is the criteria प्रोन्नति निमित्त निर्धारित न्यूनतम कालावधि पूरा करता हूँ और प्रोन्नति निमित्त निर्धारित शैक्षणिक एवं शैक्षणिक अर्हता रखता हूँ Next, मिनट the
नहीं, it's rule number 4.
रूल नंबर 4 मिनट
हाँ.
अनुसूचित जाति जनजाति अथवा सामान्य वर्ग से जिस वर्ग का हो अद्यतन आरक्षण नियमों के अनुसार उस वर्ग के लिए अधिक पद उपलब्ध हो, वरीयता सूची में उपलब्ध अधिक पदों के विरुद्ध यह विचारणीय हो तथा उनकी सेवा संतोषजनक हो। नेक्स्ट मिनट रूल 5।
Just a moment. Let's pause here for a moment. For the purposes of promotion, there has to be a vacant post in the promotional post, right? Further,
नोट फर्दर नोट न्यूनतम शैक्षणिक एवं प्रशैक्षणिक अर्हता एंड कालावधि नोट टाइम पीरियड एंड द क्वालिफिकेशन नोट माई रिलेवेंट क्लाउज 2 मिनट ग्रेड 4 के प्रोन्नति के लिए स्नातक प्रशिक्षित नोट ग्रेजुएट ट्रेन तथा ग्रेड 2 एवं ग्रेड 3 में शिक्षक उपलब्ध नहीं होने के चलते ग्रेड 1 से ग्रेड 4 में प्रोन्नति की दशा में ग्रेड 1 में न्यूनतम 8 वर्ष की सेवा दिस क्वालिफाइज हम इसको क्वालिफाई करते
नहीं,
हैं।
एक सेकेंड पॉज करिए, ठीक है। फॉर प्रमोशन फ्रॉम ग्रेड 2 टू ग्रेड 1 टू ग्रेड 4.
May I read once more?
Yes,
Clause 2 ग्रेड 4 में प्रोन्नति के लिए
yes.
ग्रेड 4 मीन्स मिनट दी ग्रेजुएट इसके पहले जो डेफिनेशन क्लॉज को थोड़ा सा हम बता देते हैं मिनट 1 पेज अर्लियर मिनट दी परिभाषाएं एक पेज पहले जो देखा जाएगा परिभाषाएं स्थापना समिति से अभिप्रेत है नियम 3 में गठित जिला स्थापना समिति
That's right.
इट इज कॉम्पिटेंट अथॉरिटी
Yes.
ग्रेड 1 से अभिप्रेत है मैट्रिक प्रशिक्षित मूल वेतनमान 1200 से 2040
You are in this? Are you in grade 1?
At present, I am in grade 7.
Where were you? In which grade were you appointed?
Grade 1.
Grade 1.
In the year 1994.
1994.
Right.
Grade 1. So you were matric prashikshit.
My appointment was on the matric scale.
Okay, fine.
Thereafter, milord, the further grade 2 means milord the bariye vetanman. Matric prashikshit bariye vetanman. It is the scale milord.
You were granted this?
Milord.
You were granted this?
Milord, I
When were
have
you
been granted grade 1 to grade 4 directly as per the.
Okay, so you were not granted grade 2 and grade 3. You moved from grade 1 to grade 4.
Grade 4.
Okay.
That has been granted.
Okay.
Milord.
When was it granted?
Milord, in the writ petition itself, milord, annexure.
You give me the date. We'll just first see the rules and then come to the facts.
Milord,
When were you granted?
Granted 1/4/2003 with effect from 1/4/2003 by memo number 1485 19/10/2009. That is annexure 1 minute page number 26.
Okay. So grade 1 to grade 4 you were granted. With
After the 8 years of the service minute from 2003 it has been granted, but it is granted belatedly on 19/10/2009.
Yes. So you have any grievance in connection with this promotion?
Milord, in this promotion, Milord, I have been granted with effect from 1/4/2003 with all monetary benefits.
Okay.
I have no grievance regarding grade 4 promotion.
Okay, fine.
Now, Milord, as per rule, Milord, a teacher works for 5 years in grade 4, then he will be granted grade 7 promotion as per rule, Milord.
Let us see that.
Milord, the rule, Milord, clause 4, 5 का clause 4, Milord, grade 7 में प्रोन्नति के लिए
Yes.
स्नातकोत्तर प्रशिक्षित ग्रेड 6 अथवा ग्रेड 5 में पर्याप्त शिक्षक उपलब्ध नहीं होने की स्थिति में ग्रेड 4 से ग्रेड 7 में प्रोन्नति की दशा में 4 वर्ष में न्यूनतम ग्रेड 4 में न्यूनतम 5 वर्ष की सेवा। टीचर वर्क्स फॉर 5 years in grade 4, he is qualifying for grade 7 promotion. That promotion also granted to me. Milord, that is
When
Milord,
were you granted this
Milord,
promotion?
I'm just saying. Milord, the annexure to page number 28.
What is the date?
Lord, it is granted, my lord, with effect from 1/4/2009. Petitioner is at serial number 6, Nishikant Jha, राजकीय मध्य विद्यालय आश्रम स्वयं प्रोन्नति की तिथि 1/4/2009. It is granted by memo number 157 dated 22/2/2019.
22 with all financial benefits.
No, in this promotion there is no financial benefit.
Anything denied? Has the financial benefits been denied to you
Yes,
by the
ma'am.
impugned order?
There
Which
is
is
no
under
impugned order. There is no impugned order, though it is granted in 2019. Lord, I
Where
have
is that?
relied.
Where is that? Let us see. This order.
Lord, the order is at page number 28, annexure 2, promotion order में, along with other person, Lord, next case में दूसरे लोग हैं जो,
Just a moment. Nishikant Jha.
Lord, serial number 6, राजकीय मध्य विद्यालय आश्रम, इतना ऊपर जो पढ़ देते हैं,
Okay.
जिला स्थापना समिति की बैठक निर्णयानुसार निम्नलिखित शिक्षक
That's right. Okay, done.
Well,
But no financial
No.
benefit has been given to you so far. Have they denied you?
Lord, it is, Lord,
Have they denied you by any order?
only, Lord, the benefit of fixation has been given, and Lord, the मौलिक नियमावली के नियम 22(1)(a)(1) Lord स्पष्ट नहीं लिख रहे हैं, लेकिन ये फाइनेंशियल रूल का जो कोट कर रहे हैं उसका मतलब वही होता है केवल फिक्सेशन का बेनिफिट देंगे.
आप एज्यूम कर रहे हैं.
This
अगर
rule-
ऐसा है तब तो आपको इसको चैलेंज करना होगा ना.
Lord, ये जो रूल में बोलते हैं कि वन इंक्रीमेंट, दिस रूल स्पीक्स Lord, प्रोवाइड Lord, कि only one increment shall be added. ये रूल में ही लिखा हुआ है, प्रमोशन रूल में ही
So
है.
therefore you are aggrieved by annexure 2.
Lord, not agreed.
Then
This by this letter, my lord, the promotion has been granted. I have, my lord, given the promotion to the post of headmaster with effect from 1/4/2009. Lord, but so far as the monetary benefit of this promotion, my lord, has not been extended. One hand, the grade 4 promotion monetary benefit has been extended. The other hand, my lord, the monetary benefit of grade 7 has not been extended.
where is grade 4 monetary benefit? This
No.
where is grade 4 order? Just a moment. Annexure
Grade 4
1.
annexure 1, my lord.
इसमें भी तो 22(1)(a)(1 लिखा है.
हाँ, वन इंक्रीमेंट इसमें भी ऐड कर दिया गया है.
We do not know what is it. Things which are not there.
Lord,
with
I
us,
am
we do
relying
not.
upon, Lord, the judgment of the, Lord,
तो आप
the.
सीधा जजमेंट में पहुंच जाओ. Where is your name?
Lord, Nishikant Jha,
Serial number?
Lord, grade 1 promotion, Lord, the annexure 1, page number 27 at serial number 21.
20. All financial benefits given. All arrears of salary, etc. given.
Lord, for the purpose of annexure 1, it is given,
Okay. For the purposes of annexure 2, it has not been given.
not given.
Okay, fine. This is your grievance?
Well,
That is the only grievance?
only given.
So you are seeking a mandamus?
Well,
So according to you, it is covered by which judgment?
Lord, the annexure 3 series, Lord,
Give me one judgment.
Lord, one judgment, Lord,
Which is the best one?
Lord, 2 judgment I am relying upon, Lord.
Okay.
Lord, the first judgment annexure 3, page number 29, para 19 is very much relevant. Page number 37. The Lord, the Dr.
29.
Parasnath Prasad, birth state of Bihar, 1991, BBCJ 1, 1990, Lord.
This is 1991. This is prior to coming into force of these rules. When you are relying upon a judgment, you should rely upon a judgment which is relatable to this particular rule.
May
This
not
is something
considering
like
this judgment, may not, and another judgment, may not, I have
Show me any judgment which deals with this particular rules. Then only we can say that it is a covered
May
case.
not the
Otherwise, we do not.
judgment, may not speaks, may not the any promotion which is granted retrospectively, always attached with the monetary benefits. Promotion cannot be granted without monetary benefits. This is the issue decided in all 5 judgments.
There is no concept of giving notional promotion
No, madam. Notional promotion,
cannot be granted,
madam,
cannot be given.
notional उसी को तो डिस्कस किया गया है कि notional always promotion can be
तो रूल
granted.
58 जो हमारा
उसी को जो इसमें डिस्कस किया गया है. Rule 58 and
बताइए
74.
कहाँ है delete
मतलब,
किया? बताइए
मुझे पेज नंबर 29 में बताइए. इसमें प्लेसिटम को पहले प्लेस कर देते हैं. बिहार सर्विस कोड रूल 58.
देखिए प्लेसिटम हम नहीं पढ़ते हैं, आप टेक्स्ट पढ़िए. बस पहले फैक्ट पढ़िए उसके बाद लॉ पढ़िए. You read para 1 and 2. Para 1 and 2 पढ़िए.
The facts are not in dispute. I propose to narrate only those which relates to salary and scale of the pay of the petitioner and of the action of the respondent in violation of all doctrines and principles applicable to the contract of service. The petitioner herein was selected and appointed as a civil assistant surgeon on so and so, a post born in the cadre of the state health services. The petitioner, however, found that he was entitled to be promoted next below in his immediate juniors in the service. Dr. So and so, in the gradation list, he protested by filing a suit bearing title suit number so and so in the court of
फाइंडिंग पढ़िए.
not the relevant not the para 19 page number 37.
पढ़िए.
The other contention of the learned counsel for the respondent that rule 58 of the Bihar Service Code shall prohibits any right of pay and allowances to the petitioner on a financial, fictional and not the notional promotion granted to him, in my view, misconceived. A notional promotion has to be as if for service benefit he had been given due promotion. A person who is entitled to promotion arise is not promoted can always invoke the jurisdiction of this court under Article 226 of the Constitution for a mandamus to employer state to consider his case for such promotion. Such due promotion is not a claim of anything notional, but it is something that is really attached to the status and the service contract of the employee concerned. In such case of Alappa Narayan, Medan, State of Kerala, so and so, the Supreme Court has stated. The foregoing discussion with the reference to the paramount of
That's
this.
right, seen it.
Hello.
Next judgment.
Other
Other judgment.
thereafter, Milord, para 22, Milord, the court.
I've seen it.
And Milord,
Next
para
judgment.
23, Milord,
Next
directed.
judgment.
Next judgment, Milord, the page number 40, Milord. Milord, LPA number 200, Milord, it is reported 2023 JBKG. Milord, LPA number 211 of 2019, State of Jharkhand and other versus Dinesh Chand Mahato. Milord, the relevant para is Milord 12, 20, 21, 27 and 28. Milord, rule 58 and rule, Milord, the Milord, rule 58 deals, Milord, by the division bench, Milord, page number 43, para 12, Milord.
Can you read it?
Milord.
Read it, please.
But the rule 58 of the Jharkhand service rules reads here under as rule 58.
This is quoted.
Not quoted.
Where has it been dealt with?
Not the thereafter, para 20 minutes.
Yes, can you read it? Where is the finding in connection with rule?
Finding in connection with the rule, Milord.
You read para
No.
19 also.
Milord, may I say one thing, Milord? Rule, Milord, para 12, Milord, rule 58 is deals with, Milord, and para 13, Milord, rule 74, financial rule is also dealt by the division bench, Milord, and Milord, the rule, para 18, Milord, it is further evident from the order passed in CWJFC number so and so, disposed of by order dated so and so, that a specific direction was passed to consider the claim of the petitioner for grant of a scale of IA and BA trained scale, BA trained, as also for promotion to the post of headmaster, if any, junior to the writ petitioner has been granted such a scale promotion, and while considering the case of the writ petitioner, the state passed the order granting IA and BA trained scale and also granted promotion to the post of headmaster with retrospective effect when the junior to the petitioner was granted such benefit. The question is that if there is no fault lies on the part of the writ petitioner, respondent and his case for promotion has been considered rather junior to him
Has not been considered.
has not been considered rather the junior to the petitioner has been promoted, and if the employee approaches to the court of law and the court of law has passed the order for consideration of case of such promotion, can such employee be denied such monetary benefit retrospectively? Lord, next parameter. It is not in dispute that promotion is not a fundamental right. Rather, consideration for promotion is fundamental right. It was the specific case of the writ petitioner before this writ court, that he had filed one writ petition bearing so and so, which has been disposed of by order dated so and so, by raising grievances that for no fault of his, he has been denied grant of a scale of IA and BA trained, as also the promotion to the post of headmaster, while several juniors to him have been granted such benefit. The learned single judge has directed the respondent authorities to consider the case of the petitioner in the light of the fact that if the juniors to the writ petitioner have been granted such a scale promotion, the decision shall be taken within a specific period. In such light of the aforesaid order, the competent authority of the state of Jharkhand has taken decision of grant of IA and BA trained scale as also promotion to the post of headmaster from the date when the junior to the writ petitioner respondent has been granted. There is no dispute about the fact that the petitioner has not been provided with a chance to consideration of his claim for grant of higher scale, that is of IA and BA trained scale, and further promotion to the post of headmaster for no fault lies on the part of the writ petitioner, which led the petitioner to approach this court, and by virtue of the order passed by this honorable court, he has been granted promotion by the competent authority of the state. He cannot be denied the monetary benefit of such post, as because if the case of the petitioner would have been considered at the time when the case of the juniors to him had been considered for promotion and granted IA and BA trained scale, the writ petitioner would have been granted promotion with all consequential benefit, since it is not a case of the state that writ petitioner respondent was not eligible to get such benefit. As such, the writ petitioner has been deprived from it.
So these two judgments you are relying upon.
Well,
What is the date on which your junior has been granted?
Milord, the junior here, Milord, the juniors are not granted, Milord. Here as per the rule, Milord, as per the eligibility criteria, it falls, Milord, first promotion in 2003, which has been granted grade 4 promotion with all benefits. Milord, next promotion after the 5 years of my service, the post of headmaster promotion is, Milord, due, and that has been considered and granted by it, Milord, the order passed in 2019 with effect from the 2009 when we were I was entitled, Milord. Therefore, my lord, the promotion has been granted on the due date.
These judgments which you are relying upon is on a proposition where a junior has been granted promotion. So it was incumbent upon the state to consider the case of promotion of everybody, right? So therefore, the court held that when a junior has been granted promotion, your right to be considered for promotion crystallized on that very day, and therefore the monetary benefit was directed to be paid. But here it is not your case.
My lord, my humble submission, my lord, as per the rule itself, my lord, when the state has fails to, my lord, comply with the rule, my lord, the rule itself says.
That is not the ratio of the judgment which you have relied upon.
My lord, the rule 58.
In both the cases, the juniors were granted promotion, and therefore the person who was seeking promotion was found entitled for promotion with retrospective date with all monetary benefits, because otherwise there would have been hostile discrimination.
My lord, my humble submission in this regard, my lord, when the promotion is.
So therefore, Rule 58 is to be ignored completely in all the cases of promotion, isn't it?
The Rule 58, my lord, applies when the promotion is not granted in time because of the fault on the part of the petitioners, my lord. Here, my lord,
Where is the question of fault on the part of the
my lord,
petitioners?
the fault, my lord, in the part of the estate, it is the fault on the part of the estate.
What were you doing?
My lord,
You could have also come to the court
my lord,
that you have completed 8 years of service, so you should be granted promotion. You never approached this court for that
my lord,
purpose.
the teachers' promotion were very disputed, my lord.
We do not
Earlier, my lord, may I say, my lord, I am relying upon the rule also, my lord. Rule speaks, my lord, Rule 6 and 7, my lord. Every year in the month of December, the gradation list is to be prepared. Here, the state has never prepared any gradation list.
So you said that you have nothing to do with the gradation list. At the threshold, I asked you. You said that this case has got nothing to do with the
My lord, the
gradation list.
promotion, my lord, the annexure 1 and 2 has been granted.
Now, therefore, don't ask anything. Don't argue anything on the gradation list, isn't it?
My lord, first time it is granted promotion in the year 2009 with retrospective effect with all benefits. With all benefits, my lord, grade 4 promotion.
With retrospective
Yes,
effect from
yes.
2000.
My lord. But so far as the grade 7 promotion, the monetary benefit is not, my lord, extended. My lord, the other, my lord, the rule, my lord, the judgment का जो paragraph number 21. My lord, the no work, no pay पर भी हुजूर finding है para 21 पर. My lord, it cannot be disputed that if the employee has not discharged his duty, the principle of no work, no pay will be applicable. But the said principle is not universally applicable. If it is found that the fault lies on the part of the employee, the same issue falls for consideration before this honorable before the honorable apex court in the case of Palaru Ram Krishnaiya and others versus Union of India reported in 1989 to SCC 541. Likewise, so and so, another judgment, my lord. My lord, the next relevant, my lord, the para number 27, my lord.
That's all. What do you have to say?
Lordship, may I read few para of the counter affidavit?
25, 26 and 27.
Lordship, from para number 12. May I? That it is stated that in compliance of the order passed by the Honorable High Court in WPS number 638/2006, Arun Sinha and others on dated 4/4/2008, The department has come with a resolution by memo number such and such dated 14/12/2015.
Where is the judgment, Arun Sinha? Where is this judgment? 638 of 2006. You have annexed it?
That we have not annexed, but in the order which was annexed, Your Lordship, the operation part was there, Your Lordship.
You file your counter affidavits mechanically.
No, Lordship.
Then what is this? You are referring to an order and you don't produce it to the
Lordship,
court.
but because of this judgment, Your Lordship, we have passed an order that we have annexed in this para, Your Lordship.
So that order is need not be produced before this court. What was the order about? Anyways, read it.
Whereunder untrained teacher appointed in the year 1987, 88, 1994 and 1999 and 2000 having the educational degree of graduation on the date of the initial date of joining on the post of the assistant teacher have been given the benefit of grade 1 from their initial date of joining, but promotion in the higher grade is to be given as per the condition laid down in the promotion rule 1993. Second paragraph, Your Lordship, that it is stated that the preparation of the seniority list in terms of Rule 5.2 of the Promotion Rule 1993, the eligible petitioner has been granted promotion in Grade 4 scale with retrospective effect from 1/4/2003 by memo dated such and such 9/10/2009. Again, the petitioner was granted Grade 7 scale with the retrospective effect from 1/4/2009 by memo dated such and such dated 22/9/2019, but monetary benefit of the retrospective has not been granted. Lordship, now the para number 15, Lordship. That it is stated that pursuant to the order of the Honorable High Court in WPC 7392 of 2017 on dated 26/9/2018, the department has issued direction amending the earlier resolution number 3027 dated 14/12/2015 dated 1145 dated 18/7/2019 and while memo dated 26/8/2021, wherein it is clearly mentioned that promotion granted earlier shall not be charged, but promotion on the vacant post can be given with the retrospective effect nationally, Lordship. Lordship, on the last date of occasion, Lordship, directed to file the notification in which we have denied, Lordship. These are the notification, Lordship, with the Rule 58. Lordship, may I read the first letter, Lordship?
Is this the way you conduct your cases? From your pocket, you will show a document to the court.
No, Lordship.
And then you want
Same
this
has
to be used?
filed, Lordship, but there was a direction to show those notifications, Lordship.
What direction? So show it to the court privately. It is a private communication now because you have not served it to the other side.
Lordship, in the morning only I received this
So
notifications.
we are hearing this case for half an hour. You rely upon a notification without bringing it on record. This is not a notification. This is a letter.
Yes, Lordship. this is
Perhaps
correct.
these are not the
Anyways, we will see only Rule 58. You forget about it. Things which are not on record, we don't see. You read para 16.
Lordship, in para number 16, Lordship, I have annexed one judgment in which the promotional benefit can only be granted on the date of issuance of letter, Lordship, but I mainly rely in the para number 17 judgment, Lordship, which I have also annexed. In this judgment, Lordship, it was stated that the promotion cannot be granted retrospectively and extended to give benefit and seniority from the date of national vacancy, Lordship. Since, Lordship, they are
So
start
you
working
are
on the
questioning
post.
your promotion order.
No, Lordship, they are started working on the grade 7 in the year 2019, Lordship. Before that, they were serving their post on grade 4, Your Lordship. So they will only be granted the national benefit from 2009 to 2019, and after that they will get the grade 7, Your Lordship. Ladyship, in the Rule 58, it was also written, Ladyship, that जिस तिथि से सरकार सेवक अपने पद पर कार्यभार ग्रहण करते हैं, उस तिथि से उनको सरकारी नियमों के अंतर्गत अनुज्ञेय अन्य भत्तों के साथ वेतन की अदायगी की जाएगी। विदेशों से भर्ती किए गए व्यक्ति अपने वेतन भारत में आगमन की तिथि से लाएंगे यदि उन्हें प्रथम श्रेणी की यात्रा भाड़ा मिला है तो, अथवा भारत के लिए जहाज पर सवार होने की तिथि से लेंगे यदि वे द्वितीय श्रेणी से यात्रा प्रभार पाते हैं तो। लेडीशिप, ऑल्सो इन द फाइनेंस रूल 74, leadership, that the same was submitted that they will not get the promotion, they will not get the monetary benefit from the retrospective effect, they will only get the notional promotion, leadership.
That's right. Where have you stated that for the first promotion you were also granted all the financial benefits?
That was not submitted.
Para 19.
Para?
19 of the petition.
Yes.
That it is humbly stated, although the said promotion has been granted retrospectively with effect from the date of vacancy as indicated in the memorandum, the monetary benefit has also been extended from the said date of the promotion to the petitioner. In second date petition also, there are 4 petitioners similarly to this, they have also been extended.
You have not filed your para-wise reply, na?
No.
At your own peril. This counter affidavit is of no use.
The counter affidavit also doesn't the relevant because the petitioner in this present case, he is 10 teacher. He was appointed as 10 teacher. The whatsoever they are making that relates to the untrained teachers who has got in service training, and that rules they have the rule.
Where is your initial appointment letter?
Appointment letter. The appointment letter is there, I have but I have not on record.
You have stated that you seek leave to produce a copy of the appointment letter during hearing. Where is that? Sure.
Entire service book is also there. I have He is appointed as a Snatak Vigyan Pratikshit, but on matric trained scale.
That's all.
Rule 58 and 74 very much has been
Where is 74? Rule 74. 58 is there in service code. Where is rule 74?
The judgment itself, it has been discussed.
Quoted and discussed.
Quoted and
Where
discussed.
is rule 74 quoted?
Minute the page number minute 43 minute the of the writ petition minute.
43.
Para 12 minute deals with rule 58 minute.
The para 12 I have seen.
Para 13 minute for the ready reference rule 74 of the Jharkhand Finance rule is quoted here under as rule 74. All authorities which are competent to sanction revision of pay or the grant of concession to the government servant should bear in mind that retrospective effect should not be given to financial sanction except in exceptional circumstances without the special approval of the government. Rule 74 of the Jharkhand Financial Rule speaks about the competency of an authority to sanction revision or pay or the grant of concession to the government servant, and while exercising the power of such sanction, it has to bear in mind that retrospective effect should not be given to a financial sanction except in exceptional circumstances without the special approval of the government. Next, the provision of Rule 58 of the Bihar Service Code was subject matter before the Patna High Court in case of Parasnath Prasad, जो पहले हम मुझे अभी रेफर किया था जजमेंट को. As also in the judgment relied upon in case of Ranjit Sahai Jamwar versus State of so-and-so, as such, it is not now in dispute that judgment has already been decided by the Patna High Court with respect to applicability of the provision of Rule 58 of the Service Code and for grant of benefit from the retrospective effect. Similar issue has been considered by the Patna High Court in CWJC number so-and-so with so-and-so, wherein taking reference to the judgment rendered in case of Parasnath Prasad versus State of Bihar, another Supra, and also in judgment rendered in the case of Ranjit Sahai Jamwar and others for the State of Bihar, benefit of promotion have been granted to the writ petitioner in the said case. So far as the case in hand is concerned, it is further evident from the material available on record that the writ petitioner since has not been granted grade IA and BA trained skill and regular promotion to the post of headmaster. However, juniors to the writ petitioners had already been granted such benefits. The writ petitioner having left no option to invoke the jurisdiction of the writ court.
That's
The rule. Next, 2-3 judgments, the rule 74 and 75, page number 50, Suryadev Prasad.
in all these cases, juniors were granted.
In this case,
In all these cases, juniors were granted permission.
here
And the petitioner was left out. It is in this particular case.
we are not relying upon those parts of the.
Those parts, judgment has to be read as a whole. You cannot say that you will rely upon one paragraph and not on that.
Only with
You will
regard to applicability of Rule 58 and had it been a case, if I have been promoted.
We will consider it. Don't worry about it.
The rule, paragraph number 13 and 15 of the Suryadev Prasad judgment, it is 2010 3 JLJR. And
Where is
next,
that? Where is that?
the page number 50.
50. Yes. What is it?
In this case, the petitioner was, the 13 and rule 74 and rule 58 is very much discussed,
That's right.
after quoting, and the relevant 13 to 15 minutes. But thus, in nutshell, the facts suggest that, para 13 minutes, the petitioner's name was approved not by one but by both the DCP for the promotion to the post of chief engineer with effect from such and such. It is also clear that there was a vacancy existing, here also vacancy existing on the post, but for the substantially subsequently initiated departmental inquiry and incorrect decision of the respondent not to give effect to the recommendations of the DPCs,
That's right.
DPCs, the petitioner would have been promoted and would have been joined to the promotional post and would have got the financial benefit. here case also, my lord, if it is granted timely as per the rule, my lord, rule provides कि every year promotion is to be granted. हर महीने के अप्रैल फर्स्ट वीक में promotion grant करना है. It is mandate of the rule. My lord, here the state has fails to do so. My lord, however the petitioner, although found fit for promotion with effect from so and so, could not have been joined the promotional post on such and such. The date that the first departmental promotion committee drew up the procedure and thereafter the date so and so, the date with effect from which the petitioner was found fit for promotion by DPC, and the actual date of DPC is that is so and so, so and so. The petitioner cannot be given the financial benefit in accordance with Rule 58 of the Jharkhand Service Code as prior to the first departmental promotion committee, it was not possible to the petitioner to join the said post. Here also, because promotion is not granted, I cannot join the said post. However, after so and so, the petitioner could have been granted promotion, and his failure to join the promotional post is not due to the fault on the part of the petitioner, but exclusively on the account of wrong decision by the respondent, and therefore, in view of the law laid down in the precedent cited above, the petitioner is entitled not only to the promotion so and so, but with all
That's
consequences.
right, that's right.
Lordship, may I submit-
Thereafter, next, the page number 53, the 2003 volume 3 BBPJ, the Muhammad Hafiz versus State of Bihar. Here, the also page number 6 to 11, para number 6 to 11 of the state judgment, Rule 58 and Rule 74. Applicability is very much discussed, and it is directed to pay the monetary benefit in all the cases, pay the monetary benefit of the promotional post from the date when the promotion is granted.
So you are relying upon, just give me the list of the judgments you are relying upon.
I have the
Annexure, Khali, you just give me the annexure number. Annexure 3.
Annexure 3 series.
Annexure 3 para number.
I have given list of date and
अच्छा, you have mentioned it
सब
there.
जजमेंट को कोट करके पैरा भी
Para भी लिख दिया?
लिख दिया.
Lordship, may I submit two more things, Lordship? Lordship, the prayer of the petitioner is that they are only seeking for the monetary benefit.
Yes.
Only seeking for the monetary benefit, not for the regular promotion, Lordship. But most
They
of
have
the
already
judgment
been
there.
granted.
Granted promotion.
Yes,
Promotion is not
Lordship.
interested.
But they are only praying for the monetary benefit,
That's
Lordship. Lordship, if we see the annexure, if my petition, Lordship, I have annexed one judgment of the division bench of the Supreme Court, which was passed in the year 8 March 2022, Lordship. Lordship, at page number 55, Lordship.
Yes.
The page number 55, the fourth point, Lordship. The seniority cannot be revoked from the date of occurrence of the vacancy and cannot be given retrospectively unless it is so expressively provided by the relevant service rule. It is so because seniority cannot be given on retrospective basis when an employee has been brought in the cadre, and by doing so it may adversely affect the employee who have been appointed validly in the meantime. In view of the reaffirmation of the bench of the three judges of the court in P. Sudhakar Rao versus Govind Rao, such and such, Lordship, for the aforesaid reason, we are unable to give our imprimatur to the reasoning of the High Court. Accordingly, the appeal stand allowed, and consequently, the order pass of the Honorable Court stands set aside, Lordship. Lordship, now may I just read the letter, Lordship, which I have given, Lordship.
In the
You take out the judgment from India, can't you?
that too,
You don't have, because there are certain errors also, as we have noticed in a few citations. So we have to look for corresponding
it is
AIR
I will
or
provide the
SCC.
CC citation, Lordship. Lordship, can I just read the
Yes.
letter?
How many times will you reply to each other?
This judgment, is relating to voluntarily retired person who has claimed his promotion with the earlier, the date. I have filed reply to that, and I have para 7, I have replied that these two judgments are not relevant, and the supportive of the state stand, because the issue itself, the page number 48 make only see, the first, a voluntary retired cannot seek promotion as a matter of right some rules governing. Not, it is not relevant in the case where the promotion has been granted to the person and only the monetary benefit has been denied. And the only basis it is not expressly mentioned in the order, but Rule 58 and Rule 74, and that has very much been clarified by the judgment of this Honorable Court as well as the division bench of the Patna High Court. When the Rule 58 and 74 will be applicable.
Leadership, at last, Leadership, may I just read one letter, Leadership, which I have given, Leadership.
I will not permit you to.
Leadership, but in this Leadership, it was clearly written, Leadership.
What clearly?
Just a moment, as a bare reading, Leadership.
We do not annex. You do not file paravise reply to the writ petition, right? You do not annex the relevant documents along with the counter affidavit. We do not permit the petitioner to produce documents from their pocket. We will not allow you also to produce documents from your pocket. How you can be so irresponsible by filing counter affidavit? It is not being vetted by you. Then why don't you file paravise comments to the writ petition? There are statements made in the writ petition with regard to other petitioners, with regard to monetary benefit granted to them. You don't respond to that. You will play your own tune and argue before the court from documents bringing or producing just from your pocket. I don't know. I have never heard of such procedure. Who is a senior?
Mr. Sokumar, senior.
He does not know paravise comment. So, state councils, if they should be very careful. And I am not saying so on my own. This is the observation of the Honorable Supreme Court. If you have not read it, you better read it. Paravise comments are important. जो मन में आया सो काउंटर एफिडेविट में फाइल कर बिना देखे कि रिट पिटीशन. We'll see what is to be done. We do not. अब खत्म नहीं हुआ आपका.
नेक्स्ट केस जो उधर है, वो नेक्स्ट केस में भी सिमिलर इंसिडेंट होगा.
उसमें भी पैरावाइज कमेंट नहीं है.
नहीं है. और मिलॉट दी सेम जजमेंट वी आर रिलाइंग अपॉन मिलॉट. And milord the grade annexure 1 is milord the grade 1 milord the grade 4 promotion order milord, and milord the next milord the annexure 3 milord annexure 1 and 2 milord the grade 4 promotion, and annexure 3 page number 33 milord is the grade 7 promotion milord. The petitioners milord at milord the petitioner number 1 at serial number 7 milord the serial number 3, 4, 5, milord 8 and 9. Milord the annexure 3, page number 33. All 6 petitioners in this case, milord. Milord same memo number 157, milord. 22/2019.
You at the time of appointment were not trained. Untrained.
In first case, milord, trained.
Even in first case, you were not trained.
Milord, I was trained.
You read it from the contract. First case, Nishikant Jha.
That counter affidavit, milord, हम तो नियुक्ति
पैरा नंबर 10.
milord, हम तो नियुक्ति पत्र ही दे दिए.
नियुक्ति पत्र से नहीं पता चलेगा. पैरा 10 में लिखा है ना. You just see.
Milord, counter affidavit.
Yes.
It is wrong submission.
Wrong submission. Have you denied it in your rejoinder?
Milord,
Wrong submission. You will just make a statement from your own. Have you denied it from in your rejoinder? Then I'll acknowledge it. Otherwise, I will not. Okay. 1 to 10. No comments. Very good. रिकॉर्ड के बाद सबमिशन मत किया करिए प्लीज. आई डोंट लाइक इट. इससे एरर हो जाता है ऑर्डर में. उसके बाद रिव्यू फाइल होता है कोर्ट. You are there in the other case?
We have seen serial number 4 on this. It's one document which has been annexed with the counter affidavit. It's annexure D at page 42.
42. Yes, what is
This
it?
is clause 26A21. This is last page. I'll take your lordships. Page 44 minutes. So far as the petitioner's case is concerned, minutes regarding the notional promotion and the benefits minutes. After consideration of the judgment passed by this honorable court in Dinesh Chandra Mahto, which was affirmed up to the honorable Supreme Court. So I'll just place that. It's page 44. शिक्षकों के पारस्परिक वरीयता निर्धारण के संबंध में माननीय उच्च न्यायालय में लगभग 1 दशक तक वादों के लंबित रहने के कारण समय पर सहायक शिक्षकों की प्रोन्नति बाधित रही है, जिससे माननीय उच्च न्यायालय द्वारा अनेक वादों में भूतलक्षी प्रभाव से प्रोन्नति देने का न्यायाधीश प्राप्त होते रहा है। WPS और सचिन सच दिनेश चंद्र महतो बनाम सरकार एवं अन्य में पारित न्यायाधीश को सचिन सच में यथावत रखा गया है। अतः ग्रेड 3, ग्रेड 4 एवं ग्रेड 7 में दे नियमित प्रोन्नति संशोधित वरीयता सूची के अनुसार पद उपलब्धता की तिथि से वैचारिक रूप से प्रदान की जाएगी, क्योंकि संकल्प संकेत सचिन सच के अनुसार यह वैचारिक ही दे होगा। But so far as this I have placed because now minutes after consideration of all the judgments passed by this honorable court affirmed in the honorable Supreme Court, there is a policy decision on board which says that retrospective promotions minutes will be only given notional minutes. And the reliance minutes, heavy reliance on the judgment passed in this Dinesh Chandra Mahto case minutes. If page 47 of the petition minutes order is concerned minutes, I'll just place the small facts notes as the lordships was rightly pointing out. Page 47 of this written notes. This judgment is not applicable in the facts of the case of these case notes. Whereas I'm reading the second paragraph. The writ petitioner respondent having passed the intermediate examination, Bachelor of Arts examination and Master of Arts examination, submitted representation for grant of IA and BA scales and also for promotion of the post of headmaster, but the same was not granted. Whereas, according to the writ petitioner respondent, some of the juniors to him were extended such benefits by way of grant of IA and BA, trained skills and promotion to the post of headmaster. Therefore, the writ petitioner respondent approached before this court by filing a petition which was disposed of by order 23/7/2001 with the direction upon respondent number 2 to grant IA and BA trained scales from the date juniors to the writ petitioner respondent were granted to the said scales and to consider the case of writ petitioner respondent for promotion of the post of headmaster from the date juniors to have been promoted. When the order dated 23/7/2001 passed and such was not complied with, the writ petitioner respondent filed a contempt case. However, after filing of the contempt case, the respondent number 2 granted IA and BA trained scales and also the scale of headmaster to the petitioner respondent such, respectively the date on which juniors to him were granted such benefits, but arrears of monetary benefits were not given to them. And therefore, that was rejected and they came before this honorable and therefore this LP order. So the factual aspects are different. There was a discrimination so far as the vis-a-vis their juniors and therefore that order minutes. And there is a list of dates minutes I have prepared with 2 judgments of the Honorable Supreme Court minutes on the point of areas of salary so far as the notional promotion is concerned. First is 1996, volume 7, SCC, 533 minutes. Para 6 minutes. Para 6 minutes. Having regard to the above contentions, the question arises whether the respondents are entitled to the areas of salary. It is seen that their entitlement to work arises only when they are promoted in accordance with the rules. Preparation of seniority list and Rule 9 is a condition precedent for consideration and then to pass an order of promotion and posting to follow. Until that exercise is done, respondents cannot be posted in the promotional posts. Therefore, they are contention that though they were willing to work, they were not given to work after posting them in promotional posts as no legal foundation. The rival parties are aggregate with their right to seniority. Ultimately, this court had directed the applicant to prepare the seniority list strictly in accordance with Rule 9, untrammeled by any other inconsistent observation of the court or the instructions issued in contravention thereof. Since the order had become final in 1990 when the appeal had been disposed of, paragraph 8 I am placing. 7 and 8 both notes. This court in such and such considered the direction issued by the High Court and appealed that there has to be no pay for no work. That is, a person will not be entitled to any pay and allowance during the period for which he did not perform the duties of hired post. Although after due consideration he was given a proper place in the gradation list, having been deemed to be promoted to the hired post with effect from the date his duty was promoted, he will be entitled only to step up the scale of pay retrospectively from that deemed date, but is not entitled to the payment of arrears of the salary. That's now paragraph 8 now. It is true, as pointed out, such and such, that in Union of India versus Jharkhand, the court had held that where the incumbent was willing to work but was denied the opportunity to work for no fault of his, he is entitled to the payment of arrears of salary. That is a case where the respondent was kept under suspension during the departmental inquiry and sealed cover procedure was adopted because of the pendency of a criminal case. So
This
therefore,
fact is not there.
and therefore, as paragraph 9 says, in these appeals, unless the seniority list is
I've
prepared,
read it.
yes, and similarly, on the basis of this judgment, one more judgment 2007, volume 15, SCC 777 plus paragraph 2. But in this case also, I'll just place 2 lines. Wherein in respect of an identical matter rising out of similar proceedings of even date, this court, by setting aside certain such, High Court allowed the appeal at the instance of the state and held that in the circumstances noticed in that case, which are identical as well as the cases before us, the question of payment of arrears of salary with retrospective effect from the notional dates does not arise, since indisputably the respondents had never worked during that period in the promotional post. The settled principle in such cases being no work, no pay. The said principle applies with equal force to the cases before us. These are the 2 judgments.
Thank you. For the learned counsel for the parties, kindly give your appearances. The learned counsel for the petitioner, by referring to the facts of WPS number 393 of 2023, has submitted that the petitioner was initially appointed as assistant teacher on 29/10/1994. And was granted promotion from grade 1 to grade 4 in terms of the promotion rules of 1993, by Annexure 1 dated 19/10/2009, along with others, and the name of the petitioner appears at serial number 21. He was granted promotion with effect from 1/4/2003 and was also given all the monetary benefits of promotional post from 1/4/2003. The petitioner has no grievance so far as promotion from the post of grade 1 to grade 4 is concerned. He submits that another promotion was granted to the petitioner along with others by order dated 22/2/2019 as contained in Annexure 2. The name of the petitioner appears at serial number 6 and he was granted promotion with effect from 1/4/2009, but monetary benefits for the intervening period from 1/4/2009 to 22/2019 has not been provided to the petitioner. The said promotion was from grade 4 to grade 7. The learned counsel has submitted that the petitioner attained the age of superannuation on 31/1/2021 from the post of headmaster cum drawing and disbursing officer at Government Girls Middle School, Rampur, Mahuatan, within the district of Latihar. Para 7 में लिखा हुआ है. The learned counsel has submitted that the petitioner became eligible for promotion in terms of the rules of 1993, but was not granted promotion for the reasons best known to the respondent, and therefore, once the promotion was granted to the petitioner with retrospective effect, the petitioner cannot be denied the financial benefit arising out of such promotion. The learned counsel has relied upon judgments passed, has relied upon following judgments. ये पूरा इसके लास्ट में दिया हुआ है, ठीक है? Written submissions filed के इसके लास्ट में. The learned counsel, so far as the other writ petition being WPS number 6028 of 2022 is concerned, he submits that similar issue is involved in the said case. कॉमन ऑर्डर्स है अलग है.
दूसरे केस में एनेक्चर 1 जो है वाइड मेमो नंबर 1272 डेटेड 5/10/2018 है विथ रेट्रोस्पेक्टिव इफेक्ट मिला. कुछ लोगों को 2004 की तिथि थे, 1/4/2004 की तिथि थे, और कुछ लोगों को जो 1/4/2004 की तिथि थे. अंजनी कुमार सिन्हा पिटिशन नंबर 1 मिलो दैट सीरियल नंबर 3 1/4/2004.
अंजनी कुमार सिन्हा
serial number 3 मिलो 6 serial number 6 serial number 7 and मिलो the other petitioners मिलो with the similar office order मिलो as first case मिलो.
ठीक.
serial number 18
Office order 22 to 2019 is common in all the cases. In this case
1910 to
19 to 2019
हाँ.
जो वो कॉमन है.
grade 7 का कॉमन है.
कॉमन.
grade 4 का
अलग अलग
एक वही लेटर है मुझे पेज नंबर एनेक्चर 2 जो है वही लेटर है जिससे कि फर्स्ट केस का मिला है.
ठीक है.
जिसमें कि सीरियल नंबर 18 19 21 एंड 22 फोर पिटिशनर मिले एंड एनेक्चर 1 से 3 पर्सन्स अंजनी कुमार सिन्हा अरविंद कुमार
ठीक.
केदार महतो 3 6 and 7.
Okay. The learned counsel, we are referring to the facts of WPS number 6028 of 2022 is concerned, has submitted that similar issue is involved in this case. The petitioner number 1 to 7 were given grade 4 promotion with effect from 1/4/2004, 1/4/2004, 1/4/2003, 1/4/2004, 1/4/2004 and 1/4/2003 respectively, and grade 7 promotion with effect from 1/4/2012, 1/4/2010, 1/4/2009, 1/4/2010, 1/4/2013 and 1/4/2009 respectively, but financial benefit. He submits that the promotion from grade 4 to grade 7 was granted by notification dated 22 to 2019 with retrospective date, but financial benefits have not been granted. He submits that identical issues are involved in both these cases. That's all. The learned counsel, appearing on behalf of the respondents, has opposed the prayer of the petitioner and has submitted that the judgments relied upon by the petitioners do not apply to the facts and circumstances of this case. The counsels have further submitted that have further referred to Rule 58 of Jharkhand Service Code and Rule 74 of the financial rules to submit that the incumbent is not entitled for monetary benefit of the promotional post unless he joins in the cadre. The learned counsel has also relied upon judgments passed in the case of in civil appeal number 5573 of 2006 within brackets state of Uttaranchal and another versus Dinesh Kumar Sharma as annexed with annexure capital E of the counter affidavit, and also judgment dated 8/3/2022 passed by Honorable Supreme Court in the case of Union of India versus Manpreet Poonam Singh in civil appeal number 517-518 of 2017 within bracket annexure F to the counter affidavit. ये है counter affidavit in 393 of 2023. The learned counsel has referred to paragraph 20 of the paragraph 20 of the judgment at page number 55 of the counter affidavit to submit that the petitioner is not entitled for monetary benefit. The learned counsel has also referred to judgments passed by the Honorable Supreme Court in the case of State of Haryana versus O.P. Gupta within bracket 1996 bracket close 7 SCC 533 paragraph 6, and also judgment which has also been followed in judgment passed by Honorable Supreme Court reported in State of Haryana versus S.K. Khoshla and others reported in bracket 2007 bracket close 15 SCC 777. The learned counsel has also referred to the impugned order to impute order nahi, has also referred to the orders passed by the authority as annexed with the counter affidavit. To submit that a policy decision has been taken vide memo number 1145 dated 18/7/2019 that notional promotion will be granted with retrospective date, but there would be but without financial benefit. Only notional promotion will be granted with retrospective date. The Learned Counsel has submitted that the entire background in connection with grant of promotion has been discussed in order number 619 dated 26/8/2021 annexed with the counter affidavit. That's all. Let me just go through the records, right? I will, day after tomorrow is court. Post this case for further dictation. Yeah, at 2:50.
Day after tomorrow is holiday.
छुट्टी the Monday को
हाँ ठीक
at 2:50. Tuesday at 2. थोड़ा देख लेते हैं अच्छे से. Let me go.
रूल 57 रूल 58 एंड 74 को सभी जजमेंट में
We'll see.
कंडीशन मैन
We'll see. उस दिन कोर्ट में ही लिखाएंगे.
मैन
फिर Passover Passover case item 5 WPS 2345 of 2023.
Yes.
will also directly come to page 44,
44.
44 of writ application. This is the list. My name is serial number. Lordship, the next page is 45. Reserved, unreserved, SC, ST, BC 1, BC 2. In my roll number is 301-85248. This is my roll number. Now it is well settled law, Lordship. Even if I have applied for the BC 1 or any reserved category, if I obtain higher marks, then my candidature will be considered under unreserved category. So they publish the result mine in unreserved category. Certainly I have scored more. And what they have done, they have simply annexed the document page 20 to the counter affidavit, which I want to file reply, which Lordship has denied it. Page 20.
I have denied it.
Lordship, yesterday my junior asked for the filing reply to the counter of rejoinder.
No.
And it was fixed for today then. Why
Oh, yes.
Yes.
What do you want to dispute in the counter?
Dispute. In page 20, Lordship, come to counter affidavit. What they have said? They have said cut-off mark. Had they have stated anywhere that the person XYZ scored 428, 427 has been appointed under BC1 or in general category, then certainly I don't have
No,
a case.
I don't get it.
No.
What do you want to say?
Why says they simply set the cut-off mark of BC1 or general category 490.
Do you
490?
dispute this also?
Yes, I dispute it because
You
they
dispute it and you file an affidavit that this is incorrect.
This is incorrect because they
You
have
file
to,
an affidavit because
Yes.
because now you will say that the court has denied you the opportunity.
Yes, obviously.
When will you file it?
Within a week I will file.
WPS number 2345 of 2023. Counsel for the parties are present. Counsel for the petitioner has submitted that
Lordship,
The figures mentioned in-
आएगी वो
हाँ तो एक हफ्ता में
Lohdaka said she is also practicing advocate.
Very.
To
So she should be all the more vigilant about it.
Obviously.
The learned counsel for the petitioner has submitted that, has referred to para 45 of the writ petition to submit that the roll number of the petitioner being 301852448 has been considered under unreserved category, which itself indicates that the petitioner had secured more marks than the other selected candidates under the BC category.
Yes, BC1 category.
BC1 category.
Yes.
The learned counsel further submits that the statement made in the counter affidavit that the last selected candidate under BC1 category,
They have not stated.
they have stated that the last selected candidate under the BC1 category scored 429 marks and the petitioner scored only 420 marks is apparently incorrect. He submits that the petitioner is a practicing advocate and therefore he wants to
Also
file.
para 11.
Yes,
they
para
have
11.
not stated.
They
They have no.
You just respond to that.
Yes, I will respond. What they have stated, the cut-off mark is 429. They have not stated the last candidate who has been appointed.
Cut-off marks means what?
The last
Cut-off mark means this is the cut-off mark. One have to obtain this marks, then they will be selected.
Show me something from the advertisement that there has to be a cut-off marks of that nature.
They have to. They have not filed. They have rather misleaded this code. They could have stated.
You give me instance of one BC candidate who has got less marks than you has been selected.
That is that.
The learned
they
counsel
don't-
for the
they-
petitioner also submits that he shall file an affidavit, he shall file a rejoinder to the counter affidavit, clearly stating if any of the candidate, clearly stating the details of the candidate under BC1 category who has secured less marks than the petitioner and has been ultimately selected. आ जाएगा तभी काम होगा. ठीक. Pose this case on 10th of April, 12th of April, 15th of April.
15.
On 16th of April in the supplementary cause list, let this matter be treated as ordered. चलिए.
Yes. And one more thing, Dr.
अब कोई और time मत
नहीं इस केस में नहीं बोल रहे. हजूर कल बोले थे हम सेलेक्टिव केस में अपेयर करते हैं, हम हर कोर्ट केस में आपके यहाँ अपेयर करते हैं.
4 बार आपका केस पास ओवर हुआ.
वो और भी कोर्ट में अपेयर करते हैं.
बहुत अच्छी बात है.
एक
तो
बार
हम बोले
हजूर एक बार भी बोल दीजिए कि आपके कोर्ट में कौन सा केस हमने अवॉइड किए.
अवॉइड करने की बात नहीं है. आप अपने
केस
जूनियर
अच्छा
को
हो
भी
जाता
तैयार
है,
नहीं,
हर दिन बहस करते हैं.
आप अपने जूनियर को भी तैयार नहीं करते हैं.
जूनियर को हम रेडी करते हैं, मगर
रेडी
इसमें हम
कर-
रिजॉइंडर फाइल करने के लिए बोले थे
तो
और इसको
फैक्ट
रेडी
तो
भी करके
बताना
भेजे.
चाहिए ना. कुछ नहीं, एकदम साइलेंट. कल का रिकॉर्डिंग देख लीजिएगा. अब तो कुछ बात तो है, कोई बात थोड़ी है. अब जब आप ये बोल दिए कि आई हैव आस्क्ड यू नॉट टू फाइल, तो इट इज अ रिकॉर्डेड प्रोसीडिंग. कल को एलपीए में बोलिएगा रिकॉर्डिंग देख लीजिए.
हाँ
हाँ, इसलिए
मेरे को अपॉर्चुनिटी मिला ना
हाँ,
फाइल करने का.
इसीलिए judge, as a judge also I am very careful about whatever I am stating. And since you have pointed it out, I am giving you time to file.
Okay.
But don't ask for any further time.
No, definitely.
चलो.
Whatever the result be, वो हम reply फाइल करते हैं उसका जो होना है.
From the daily list, item 4, WPS 4827 of 2023.
In this case, petitioner has played for the issuance of writ of mandamus to fix up the pension of the petitioners in terms of 6th pay revision and make the payment an immediate difference of pension. And further prayer has been made for crossing of annexure 17, page 74, whereby order dated 16/6/2017, whereby the petitioner's claim has been rejected. And further, next prayer in worship to pay that gratuity amount of rupees 10 lakh, payment has already been made to rupees 3 lakhs.
I want to know from the state, what is the gratuity amount being paid by the state and with effect from which date?
ये रिटायर्ड किए 31/5/2010 को।
स्टेट कितना देता है? आपने तो 2011
ग्रेजुटी एक्ट से गवर्नमेंट
मतलब it is being given from 31 state government employees who are retiring on 31/5/2010 are being granted the relief.
नहीं 30 ये इस केस में रिटायर्ड किए 31/5/2010 को और बाद में सब्सिक्वेंट अमेंडमेंट आया है। इनका कहना है कि 10 लाख रुपए हमको दीजिए, 10 लाख इनको मिलेगा ही नहीं, 10 में ये रिटायर किए हैं और अमेंडमेंट आया है सब्सिक्वेंटली 2017 और 18 तक। उसके बाद क्या
2011
17/11 को ठीक है।
2011 को है।
पेमेंट ऑफ ग्रेच्युटी एक्ट में कब अमेंडमेंट आया?
11 में
नहीं उसमें 24/5/2010 को मेरा स्टेटमेंट है।
नहीं, आपका स्टेटमेंट से
आपका
तो नहीं चलेगा ना।
अमेंडमेंट कब आया वो
अमेंडमेंट कब आया बताइए?
बिहार झारखंड स्टेट हाउसिंग बोर्ड का अमेंडमेंट आया है 17/2/11।
हाउसिंग बोर्ड
That's
अमेंडमेंट
it.
Board of
आप
Director-
क्वेश्चन को मत चेंज करिए, हम जानना चाहते हैं पेमेंट ऑफ ग्रेच्युटी एक्ट में अमेंडमेंट कब आया? व्हाट इज द डेट ऑफ अमेंडमेंट?
24/5/2010 एज पर आवर स्टेटमेंट।
You show me from that.
दस लाख
Which section is that?
सेक्शन 4 सब सेक्शन होगा इसका।
Three lots.
Three में controlling authority.
And they, 3 हम पढ़ देते हैं, the amount of gratuity payable to an employee shall not exceed 10 lakhs rupees. नीचे में 15 में है।
कहाँ पे 3 में? आप 3 is the controlling authority.
नहीं कमिट 4 है पेमेंट ऑफ ग्रेच्युटी, सब रूल 3,
सब रूल
सब रूल 3,
subsection 3.
हाँ सबसेक्शन 3, subsection 3, the amount of gratuity payable to an employee shall not exceed 10 lakhs rupees. Lordship has got it.
Yes.
And then Lordship just bottom 15 substituted by the payment of gratuity amendment at 2010, 15 of 2000 section 2 for 3,50,000 with effect from 24/5/2010. 24/5/2010.
ये जरा देखिए, दिखाइए जरा।
And on that basis,
नहीं, you just have a look at it. There is a
नाम देख
great
लीजिए
confusion.
पेपर से मिल गया।
2018 लिखा हुआ है इसमें।
ये फर्दर अमेंडमेंट हुआ है 18 में, 2 बार अमेंडमेंट हुआ है।
2 बार अमेंडमेंट हुआ। पहले 7.5 हुआ था, 3 से 7.5 हुआ था, उसके बाद 2018 में 10 हुआ। I just want to know, state is a party here?
स्टेट नहीं, ये हाउसिंग बोर्ड का वाला।
State is a party or not a party?
Yes, state is party.
State is a party. I just want to know from you, for this, you see, it is one thing to say the moment the Payment of Gratuity Act is amended, the state government employees are entitled as per that. It is another thing to say that there has to be a decision taken by the state government and then they fix a date.
Yes.
What is the position? Housing board has fixed a date. What about the state? ऑटोमेटिकली लगेगा कि स्टेट से कुछ नोटिफिकेशन हो के शुरू हो?
नहीं, हम तो जब एक्ट में आ गया तो ऑटोमेटिक लगेगा।
तो इनका 2011 से क्यों कर दिया? Because all the provisions were made applicable.
Yes.
Then why this 2011 cutoff date has been given?
हाँ 17 to 2011 हम लोगों ने लिखा है।
Why?
बोर्ड ने ठीक है तो डिसाइड कर लीजिए। 10 लाख इतना नहीं होगा, इनका हो जाएगा।
If you are sure about it, I will record it right now. That by virtue of amendment, it automatically applies and no further notification is required to be issued by the state government.
मैं इसको तो एग्जामिन नहीं किया है।
एग्जामिन नहीं किया है तो एफिडेविट फाइल करके एग्जामिन करिए।
देखना पड़ेगा।
आप स्टेट हैं?
Yes.
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioner has been granted gratuity of rupees 3.5 lakhs.
Yes.
3.5 lakhs only. He retired on 31/5/2010, and the Payment of Gratuity Act was amended with effect from
24/5/2010.
24/5/2010, and therefore he was entitled for gratuity to the extent of rupees 10 lakhs. The learned counsel submits that as per the impugned order, the respondent board has taken a decision to increase the amount of gratuity from 3.5 lakhs to 10 lakhs by order dated 17/2/2011,
Yes, sir.
on account of which the petitioner has been denied the gratuity of 10 lakhs. The learned counsel has also submitted that the petitioner was governed by the rules which were applicable
Yes.
to the state government employees,
Yes.
and if the state government employees were entitled for gratuity to the extent of rupees 10 lakhs, who had retired on or after 31/5/2010, then there can be no reason to deny the same benefit to the petitioner. The learned counsel appearing on behalf of the state is directed to seek instruction and file a counter-affidavit in connection with the averments made by the submissions made by the learned counsel for the petitioner. The counter-affidavit should clearly indicate the date from which the state government employees have been extended the benefit of 10 lakhs of gratuity. The counter-affidavit should also indicate as to why the same benefit be not extended to the petitioner. The counter-affidavit of the state be filed by 23rd April. छोटा सा बात है, कोई ऐसा चीज नहीं. Mainly तो यही है आपका. That is the only thing.
They only ने pension भी डिमांड कर रहे हैं कि since the government rules is applicable to the employees of the Bihar State Housing Board, Jharkhand State Housing Board, so I am also entitled for pension. And except 12 of my writ application, they have formulated.
Just the learned counsel for the petitioner has submitted that further grievance of the petitioner is that the petitioner is also entitled to pension at par with the state government
Yes,
employees.
Not pensionable service board का.
Sorry.
This is not pensionable service.
Maybe, but an except 12 will be seen.
इनको आखिर पेमेंट तो हाउसिंग बोर्ड को करना है.
Housing board.
Housing board. We'll decide that. That is a separate
Provision
issue.
हम लोग के यहाँ provident fund scheme में हम लोगों ने policy लिया हुआ है, and under that scheme they are entitled to get something from the provident fund EPF, not from the housing board. But there is no provision for payment of pension in the board.
Okay. The learned counsel appearing on behalf of the housing board has submitted that the petitioner is entitled for a certain benefit under the provident fund scheme, but the service is not a pensionable service. आप अपना एफिडेविट फाइल कर दीजिए 23rd तक, पोस्ट ऑन 24th.
Item 5 WPS 6259 of 2023.
आपके और भी ऑर्डर्स होंगे, आप देख लेंगे. हाउसिंग बोर्ड के और भी ऑर्डर्स होंगे, हमको याद है एक आध केस में ऑर्डर किए भी हैं. हाँ, पेंशनेबल नहीं है, दैट आई नो, बट आई डोंट रिमेम्बर द एग्जैक्ट जजमेंट. Yes, please.
In this case, my lord, I have to file a supplementary affidavit on the averments made by the petitioner in the supplementary affidavit paragraph. I
Yes.
wrote to JSSC to reply to that paragraph which they have given an affidavit, which has not of course been filed to the court, in which the commission has decided now to review their earlier decision and to recommend the name. If permitted, I can give it to the court, or I will.
On
file
behalf
it.
of the commission?
Yes, it is in my.
Though, so you should be happy with that?
Then in
I'm
that
given a copy. To my learned friend, I'm given a copy. My lord, please come to para 5 also.
7 and 8 is
Yes, yes. My lord, only go to 7 and 8, my lord. May I read, my lord?
Yes.
That after re-scrutinizing the certificate of the petitioner, the respondent commissioner has taken a decision to recommend the petitioner for appointment to the respective department subject to fulfillment of the prescribed qualifications and other terms and conditions. Accordingly, necessary action is being taken in this regard at the level of commission. That after recommendation of the petitioner will be sent to the respective department after the Lok Sabha elections 2024. considering
I should
the-
record it, that should be sufficient.
7
I
and
dispose
8
it of.
7 8 रिकॉर्ड करके इसको डिस्पोज ऑफ कर दिया जाए. एक लेयर मेरा रहेगा.
Time frame.
टाइम
फ्रेम अब तो पता चल गया ना लोकसभा इलेक्शन
इलेक्शन
कब
के
है.
बाद
इलेक्शन के 10 दिन बाद
4 वीक्स दे दिया जाए, हम कर देंगे, हम तो अंडरटेक कर रहे हैं.
फिर
लेकिन जो इसमें कोर्ट ऑर्डर करेगा हम वही करेंगे. हमारा बंदिश मात्र लोकसभा इलेक्शन में.
ठीक.
ये
बाकी जो
स्क्रूटनाइज
कोर्ट
कर
का
लिए हैं.
हम इसको डिस्प्यूट कर नहीं रहे हैं. जो ऑनरेबल कोर्ट का ऑर्डर होगा हम कंप्लाई करेंगे.
WPS number 6259 of 2023. A supplementary counter affidavit has been filed on behalf of respondent number 2 during the court proceedings which is taken on record. The learned counsel for the respondent number 2 has referred to paragraph 7 and 8 of the supplementary counter affidavit to submit that the respondent commission has taken a decision to recommend the petitioner for appointment to respective departments subject to fulfillment of other prescribed qualification and other terms and conditions, and necessary action being taken at the level of the commissioner of the commission. He has also referred to para 8 to submit that the recommendation of the petitioner will be sent to respective department after Lok Sabha election 2024, considering the prevailing model code of conduct. At this, the learned counsel for the petitioner submits that this petition can be disposed of by recording the aforesaid statements made in paragraph 7 and 8 of the supplementary affidavit filed by respondent. There is the court procedure. After hearing the learned counsel for the parties and considering the specific stand taken by the respondent number 2 in paragraph number 7 and 8 of the supplementary affidavit dated 2/4/2024, which has been filed during the court proceedings, this court finds that the following stand has been taken in paragraph 7 and 8. Quote kar dijiye isko. 7 and 8. In view of the aforesaid amendments made in paragraph 7 and 8, it appears that the grievance of the petitioner does not survive anymore so far as his candidature is concerned. However, the respondent commission is directed to take appropriate action in terms of
recommend करेंगे.
is directed to recommend the name of the petitioner in terms of their stand taken in paragraph 7 and 8 of the supplementary affidavit by 22nd of May 2020.
State is also a party. Necessary action in
आपका
terms.
पेंशन वाला भी ऑर्डर कर दें अभी से.
लेकिन वो आगे
We do not know. They will recommend. Then state क्या करेगा? अब हम लोग क्या बोल सकते हैं? Once they recommend, there is no reason that the state will not appoint.
हाँ,
Right?
हम बस
This
वही करते
repetition
हैं
is according to this system.
कि एक डायरेक्शन स्टेट के लिए उसमें टाइम फ्रेम से
हम कुछ नहीं कर
हो जाता है।
You can't do it.
Problem.
Under heading for orders with effect, item 6, WPS 1796 of 2023.
As we have removed all the defects except defect number 3 and 5. For that we have filed one IA petition for deleting the prayer made at para 1 Roman 1 and in the prayer portion, as well as in para 18 of the writ petition. Lordship may kindly peruse the order dated 4th March 2024. passed
What
by
is the IA about? You want to delete something?
IA number 9135 of 2023. This was not allowed on fellows 4th
IA
March
number
2000
9135 of 2023 in WPS number 1796 of 2023. Counsel, learned senior counsel for the petitioner has submitted that the interlocutory application has been filed for deleting the prayer made in paragraph 1 within bracket Roman 1 of the writ petition, as no order passed by respondent number 3, which has been mentioned at paragraph 9 of the writ petition, has been passed, as the petitioner never filed any revision against the order dated 16/11/2021 within bracket annexure 8. Any objection? Nobody appears on behalf
Instead
of
of paragraph 9, 18 may
respondent.
kindly be mentioned because in paragraph 18 we have mentioned about it.
Para 9 है ना? Para 9 है ना?
पारा 18 में हम लोगों ने लिखा है पारा 18 में लिखा है पारा 9 में लिखा है हम लोगों ने
आप जो आईए में लिखे हैं वही तो लिखे हैं,
जी।
बिना देखे लिखे हैं क्या? पैरा 9 में लिखे हैं ना?
पारा 18 में सॉरी मैडम पारा 18 में लिखा रिट पिटीशन का पारा 18 में पारा 18 पैराग्राफ 1 में देखा जाएगा मैडम पारा 1 ऑफ द आई
पैरा 18 कर
यस पर
ऑफ द रिट पिटीशन, ठीक है?
जी
The
इसमें
learned
काउंटर
counsel has also submitted that he shall not rely upon averments made in para 18 of the writ petition. After hearing the learned counsel for the petitioner and considering the averments made in the interlocutory application, the prayer made in paragraph 1 within bracket Roman 1 is permitted to be
as
deleted.
well in the prayer portion also.
Similar
Prayer portion of the writ petition also.
and also in the prayer portion of the writ petition, the petitioner is also directed to strike off paragraph number 18 of the writ petition. The necessary amendments be made during the court proceedings, during the course of the आप कर दीजिए synopsis setting.
And other
In synopsis also.
other defects have been removed.
You do not know.
And also, in view of this deletion, the defect number 1 and defect number 5, 3 and 5,
In view of the aforesaid,
defect number 3 and 5.
defect number 3 and 5 does not survive anymore. Office is directed to place this case under appropriate heading on next Wednesday.
We have listed for admission any dates for this.
Next Wednesday.
Okay.
Under heading for orders, item
IA disposed of.
Under heading for orders, item 7, WPL 2097 of 2019.
As per the office notice to respondent number 1 has written answer, but the workman is appearing, they have appeared.
You are appearing?
So Your Lordship, it can proceed without the
Yes. WPL number 2097 of 2019. Mr. Piyush Krishna Chaudhary, advocate, appears on behalf of the respondent, sole respondent.
workman respondent number 2.
Wakalatnama file कर दिया? He has submitted that Wakalatnama has already been filed. In view of this fact, the service of notice upon respondent number 1 is complete.
No, he is appearing for respondent number 2. Lordship says the workman has appeared. Lordship, respondent number 1,
It's an industrial dispute.
industrial dispute.
So, respondent number 1 has to appear.
Lordship, it has written answer, then I have to take.
Then you have to take steps.
Yes, because Lordship, respondent number 1 is causing the cause of this person.
Whatever it is.
As Your Lordship. As Your Lordship.
Industrial dispute has its own tenor,
Yes,
isn't it?
as Your
कल को
Lordship.
कोई ऑर्डर होगा तो उसी को चैलेंज करके आपके फेवर में ऑर्डर होगा तो यही बोल के चैलेंज करते
ठीक है।
कि हमको नोटिस नहीं डिलीट करना है डिलीट कर दीजिए हमको
डिलीट
कोई
नहीं
issue
कर सकते
हाँ।
because they address the
जब आप
industrial
डिलीट नहीं कर सकते तो नोटिस भी हम वेव नहीं कर सकते
As Your Lordship.
पार्टी बनाए है तो नोटिस करिए
I'll take fresh steps.
respondent number 2 has appeared. ठीक है. The learned counsel for the petitioner is directed to take fresh steps for service of notice at the present and correct address of respondent number 1. Through ordinary process,
Ordinary process.
that is better.
Yes, Lordship. That
Through,
is.
through ordinary process, the requisites be filed by Monday.
10 days के present address ले लेंगे जो registered address था
अच्छा,
वो
हाँ.
देख लेंगे.
The requisites be filed by 22nd April.
Registered.
Close this case on 11th of June, awaiting service report. एक महीना तो देंगे ना डीम्ड सर्विस के लिए भी छुट्टी पड़ जाए.
The interim order will get extended till that.
इंट्रीम ऑर्डर है आपका? The it is expiring today.
There is nothing mentioned. It is a till appearance. So they have appeared.
तो हो गया. It is continuing. इसके लिए करने का क्या जरूरत है? Respondent number 1 has not appeared.
Item 8, WPS 3296 of 2023.
This petition.
In this case, Lord, on our Gujarat side, direction has been given to file complaint. Thereafter, again, on Chera, no notice has been issued,
So,
and
6 and 7.
4, 5 and 6 का आ गया. 3 and 7. For who is appearing for respondent number 7?
4, 6, 7 में.
I am on behalf of respondent number 2 and 3, my lord.
2 and 3. Okay. नाम बताइए.
T.N. Mishra.
T.N. Mishra. Mr. T.N. Mishra, advocate, appears on behalf of respondent number 2 and 3. Your file वकालतनामा.
No, my lord, I will file it along with counter.
He undertakes to file. You file your वकालतनामा first. He undertakes to file वकालतनामा by Monday.
Some more time. हमको मंगाना पड़ेगा my lord, उसको कलकत्ता से आता है.
He submits that he shall file वकालतनामा along with the counter.
Counter.
2 and 3 हो गया. अब बताइए कौन है?
4 and 7.
4 and 7.
4 and 7. Mr. नाम बताइए.
Mohammed Asgar, AC
Mohammed
to Mr.
Akhtar.
Manish. Mohammed Asgar,
Asgar.
AC to senior, AC to Mr. Manish Kumar. Manish Kumar ही file
आपका नाम काफी नहीं है क्या?
हम on record हैं मनीष कुमार के behalf में हमें
Associate Counsel of Mr. Manish Kumar, Advocate,
Hmm.
submits that he has entered appearance, file कर दिया वकालतनामा, on behalf of respondent number
4 and 7.
4 and 7. As per the records, as per the office note, the notice has been validly served upon respondent number 5 and 6. कौन बचा? हो गया सर? 2, 3, 4, 5, 6, 7. In view of the aforesaid facts and circumstances, the service of notice is complete.
Respondent number 1, Union of India.
The learned counsel for the respondent number 1 is present. Counter file करना आप लोग को.
The petitioner was working with respondent number 6 and 7.
Okay. No,
Yeah.
no relief has been paid for. The learned counsel for the Union of India has submitted that no relief as against Union of India has been paid for. Accordingly, no counter affidavit is called for from Union of India at this stage. The learned counsel appearing on behalf of the other respondents are pray for and are granted time till 3rd of May 24 to file the counter affidavit. Post on 7th May.
Item 9 WPL 5141 of 2023.
Yes, petitioner.
Was they are challenging an order passed under the Minimum Wages Act.
What is your point?
The point is that they have held that the workmen labor employed by me in a mine of UCIL, it's an open cast mine. But there is a notification of the government of India that says even if an open cast mine, if the difference between 2 points, the highest and the lowest is 6 meters, it will be below ground, not underground, below ground. And the wages for below ground is higher than wages on ground. We have paid them wages at the rate applicable to on ground. They say since there is a report which shows that the distance is more than 6 meters, therefore you have failed to pay higher charges, you are liable to pay this. This is the point. Now my submission, that number one, the report on which this finding has
What
come.
is the date of the report? And what is the period?
Yes, ma'am, just. Well, report is that's called an inspection note dated 15/2/2012.
And what is the period?
The period is known as my working period.
Which period? Prior to this?
I'm sorry.
Prior to this period?
Yes. This is report. It is said. We do not have a copy. That's my specific case. I was never given this copy of the report. Now kindly come to page 66.
60?
66, a part of the order. We had taken a plea of limitation that has been condoned, because that is a secondary ground that the limitation should have been condoned. But issue number 2, page 66, your Lordship will see.
Yes.
Issues your Lordship will find at page 65.
Yes.
Just have a look at the issue and then I'll come to again the finding. This is the most important issue. Whether the orders have come to page 65, whether the workers involved in this claim application are entitled for wages at minimum rates of wages of the below ground rates as notified by Government of India by notification number so and so dated 20 May 2009. Now page 66 your Lordship, where the discussions. The opponent has contended that the mines are open cast mines and the workers have never worked in below
It
ground.
is echoing.
I think so.
ये echo को जरा ठीक करवाइए. Yes.
The opponent has contended that their mine was open cast mine and the workers have never worked in below ground and they are paying the minimum rates of wages on the above ground as fixed by the government under the Minimum Wages Act. Therefore, the workers concerned are not entitled to differential wages at the rate of below ground as claimed by the applicant. Now, on perusal of the inspection note dated 15/2/2012, it is evident that establishment of the opponent was inspected by Sri Hemant Tirki, Deed and Elio C. Chaivasa in presence of Sri D. Mitra, Project Manager, Mrs. Gulf Oil Corporation, Sri Sanjeev Ranjan, Assistant Manager Person, Mrs. UCIL, wherein it is clearly mentioned that by the applicant that during my visit of Bandhurang mines, it was seen that the mines has a depth of more than 6 meters from the surface level and the workers are engaged in mining work. In the said inspection note, the above named representative of UCIL, of Mrs. Gulf Oil Corporation, that is the petitioner, and Mrs. UCIL have put their signature without raising any objection on the above observation of the applicant. As per section 3 of the Minimum Wages Act, the appropriate government shall fix minimum rates of wages payable to employees employed in employment specified in part 1 or part 2. This melody is just the law. If you lordship just come to the bottom of this paragraph, where there is a reference to the notification in bold. If you lordship in this fourth last line, in the said notification, in the said notification of the Government of India at para 6 of page 18, it has been explained that a person working or employed in or in connection with a mine is said to be working or employed below ground if he is working or employed, one, in a shaft which has been or in course of being sunk, not applicable; two, in any excavation which extends below superadjacent ground, not applicable; three is what they rely upon, in an open cast working in which the depth of the excavation measured from its highest to its lowest point exceeds 6 meters. Now, your lordships have noted the language of this provision. May I just repeat it? Your lordship will have to see what does it say. The depth of excavation from the highest to its lowest knee exceeds 6 meters. And what does the report say? Report says, if your lordship just turns back, during my visit of the so and so mine, it was seen that the mine has a depth of more than 6 meters from surface level and workers are involved. So what the first point is, procedurally, this report was never given to me. That I have stated so specifically in my writ petition. Number two, the requirement of the notification is something different from the report.
How is it different?
Different is, if the excavation, when the open cast mines, it has to be excavated, that excavating points have to be the highest and the lowest have to 6 meters. Here they are saying from the surface. Surface may be different for the purposes of that may not be the starting point of the mine. But those are very technical. Let us not get into that. As of now, my first point is that this report was never given to me. The LEO was not ever examined. Number two, after I led evidence, on the same day, the RLC closed and we kept on saying, give us an opportunity of making arguments. They said, no, this is a 10-year-old case, no need to make arguments. So this entire order has been passed without even making any submission. And I can establish that no opportunity was given to make any arguments.
Where is the you are there for Union of India?
That's
Where is the private respondent?
private respondents. Okay. They are the government only. The respondent 3 is also.
Okay. You have filed respondent number 3?
One.
You have filed your counter-affidavit?
We have not read.
You produce the records.
Okay. Yes.
Learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the impugned orders is not only contrary to the provision of law, but has been passed in gross violation of principles of natural justice. The learned counsel submits that the report on the inspection note dated 15/2/2012, which has been relied upon by the respondent, was never given to the petitioner in spite of specific demand.
No. I never knew this existed.
Okay.
It has only I have said so in my
officers
paragraph.
had put your signature.
Yes. It says we don't know. That's for
Was never provided to the petitioner during the course of proceedings. The learned counsel further submits that that otherwise also, the learned counsel further submits that no opportunity of hearing was
Yes.
granted to the petitioner while passing the impugned order. The learned counsel further refers to the extract of the inspection note dated 15/2/2012 as mentioned in page 66 of the writ petition to submit that they have measured 6 meters from the surface level, and the notification on which the respondents are relying has been quoted at bottom of page number 66. The relevant is Roman 3, and he submits that in an open cast working, it has been provided that the depth of the excavation measured from the highest to its lowest point should exceed 6 meters.
Yes.
He submits that the highest point would be referable to the point of excavation.
Point where the excavation starts.
Point where the excavation starts and is not referable to the surface level.
Yes.
The learned counsel appearing on behalf of the respondents is directed to seek instructions and file a counter affidavit in this case. The records of the case be also produced and the next date of hearing. Post on थोड़ा सा सेकंड वाला सबमिशन थोड़ा सा डाइसी.
वो मेरा टेक्निकल है, but उसको explain करेंगे. I will have to explain your option because then
They might be having some kind of circulars also. We do not
this
know.
is the only notification. I will annex that notifications.
Excavation तो वहीं शुरू हो जाता है जहाँ से खुदाई शुरू होता है.
हाँ, correct. खुदाई में नहीं. वो हम explain करेंगे. I know it is a tough point, but I will do.
Pose this case on 30th April 2020. आपको
Because
क्या
I have an application for stay. They are insisting on payment.
जो लेबर कमिश्नर के यहाँ से हमेशा लेट होता है.
लेट होता है, उनको जरा बोल दीजिएगा.
नेक्स्ट फर्स्ट
Late करने का कोई
फर्स्ट वीक में करेंगे.
Okay, on 1st of May, first week.
ठीक.
Labor.
The counter affidavit will be filed by 30th of May. चलिए.
30th of April.
30th April.
So since now.
May Day.
That's what I'm saying. Labor Day.
Labor Day.
I just hope, my lord, sir, since the matter is here, my lord, will indicate that they should not take any coercive step. Demand is huge.
क्या होगा कुछ नहीं.
21 लाख प्रिंसिपल प्लस कॉम्पनसेशन अवार्ड कर
क्या कर रहा है? कुछ किया आपको?
नहीं, अभी कुछ नहीं किया.
इन लोगों को कैपेसिटी नहीं कुछ करने का.
प्रोसिक्यूशन ना कर दे.
चलिए कुछ
इसके लिए प्रोसिक्यूशन ना कर.
फ्रेश फाइलिंग नहीं है.
अंडर द सेम हेडिंग मंगाते हैं.
Item 10 WPS 7 for 5/0/2020.
आईए पे भी नोटिस कर दिया जाए.
एक ही दिन आप डिसाइड ही करेंगे.
हाँ,
अगर डिसाइड नहीं करेंगे नेक्स्ट डे में.
Only for the purpose of my understanding that on stay also notice has been issued. That's the only thing. May file reply if they choose. और कुछ नहीं.
And also to the interlocutory
Yes.
application.
I can tell them that notice has been issued.
Very
May
petitioner.
This petitioner was already working as para teacher. He was a patent in 2002. But he passed for the state pilot in 2000, held in 2012. And already in 2015, he made an application against the advertisement number the advertisement as annexed 2 for appointment on the post of the assistant teacher, where he's handicapped with the restricted. And already in state also.
Where is your counter affidavit?
Well, its counter affidavit has been signed just yesterday. I have it with me, but it has not been filed.
You file it during the course of the day. We'll see it tomorrow. Post tomorrow.
It's only if 1 day would be allowed for file. I have it in my hand.
So you file it. It has not been signed.
No, it has been signed.
So you file it. You don't have appropriate clerk.
No, it's just that it's already almost done.
कुछ नहीं होगा. आप करिए. कल रख.
Fine.
फाइल कर दीजिए. आएंगे तो फाइल करा लें. 4:30 बजे तक भी आएंगे तो we will take it on. Let the counter affidavit, at the request of the counsel for the respondent, let the counter affidavit be filed during the course of the day, post tomorrow. देखते हैं क्या counter है.
Under heading for admission, item 11 WPL 2771 of 2017.
In this case, there is some.
What happened?
Let me be very frank. I need some more time. But it's just not more, 1 week, only not today. I'll do it next week.
There is an interlocutory application for vacating stay.
Next week, I'll do not today. Not will not even say because next week I'll do it. This has a checkered history. I think some facts have to be streamlined in the note rather than the list of things.
Contested.
Yes, yes.
Do we need LCR?
It may not be, but if your lordship feels
I don't, no. It is up to you. If you want it, I will call for it. Otherwise, I will not permit records on the next date.
Lordship may call for the scanned copy of the records.
Yes, yes.
बहुत है क्या?
ज़्यादा नहीं
बहुत नहीं है, but generally Supreme Court office has scanned copy should.
The scanned copy.
Scanned copy.
ज़्यादा
We don't
voluminous
get
नहीं।
physical copies.
Yes, scanned copies होना चाहिए.
The learned counsel for the parties are present. Office is directed to call for a scanned copy of the records from the court of learned presiding officer, Central Government Industrial Tribunal number 1 Dhanbad, in reference case number 38 of 2012, which has resulted in passing of the impugned award dated 27/1/2017. Let this order be communicated through fax. Post this case on date बताइए joint date.
Whenever it comes up 2 weeks, I believe it should go 3 weeks आ जाए.
आप बताइए आप.
So whatever that suits my learner.
No.
लेकिन
खाली 12th को एक ही दिन हम नहीं है, 12th को I am not available.
So let it be on 22nd of April, if it is convenient to your lordship, or 24th of April.
you will
since
file
that-
your submissions by that time.
Yes, yes.
So what I propose is, if your lordship keeps a date before that, and on that day records the receipt, if we are also given a copy, then it
No,
will be
no,
better.
no, please
No,
don't.
copy as in email, soft copy.
Soft copy of the records, we will not provide you that.
That is a court record.
I don't know.
Inspect कर लेना
You see, as long as it is the High Court record, I don't have any
हाँ, your
issues.
lordships have always been provided.
एकदम by default हम provide कर रहे हैं. लेकिन
ठीक है.
ऐसे वहाँ का record नहीं provide कर सकते.
Very good. ठीक है, so certified. So let it come on 24th minutes. We'll try and give a note also.
Also on 24th. In the meantime, the parties to file short synopsis, list of dates and the judgments. This is particular.
May I just take 1 minute? That day I was appearing from Delhi, my connection was not good. What I was trying to say is,
In this court?
before holidays.
Okay.
Don't you remember?
Yes,
That was-
yes.
What I was trying to say is that when we appear through VC, this mic is off. What is only on is your lordship's mic. So the arguments of the lawyers are not audible. I have already informed another court also that this hardly is an inefficient way of working in the virtual mode. Because if I can't hear what the other side is arguing,
It makes no sense.
because this cannot be muted because this is kept mute or it's like echo. So the system has to change. Like your lordship system, so far as live streaming is concerned, same system can be done so far as virtual hearing is concerned. And in one court that is already being done as a trial maybe.
The live streaming is done in
No, live streaming, the same system what your lordship is doing for live streaming. In live streaming, one can hear the lawyer, one can lordship's is also audible. Why can't the same thing be done so far as virtual hearing is concerned? Because the system has to be evolved, or else virtual hearing is not effective.
So virtual hearing for this mic to be used for virtual hearing.
No, the NIC has to help your lordship. I'm just bringing to your
It has
lordship.
been it has commenced in any court.
Court number 6, they are using a system which is like your lordship's virtual hearing. There is one common speaker or a common mic, I believe.
बता करिए. लगवा दीजिए.
Because our else it doesn't give a good picture of it.
Item 12 WPS 1088 of 2023.
Petitioner. Who's for the petitioner?
please.
So for I am appealing on behalf of respondent number 5.
What is the cause of action?
My lord, the prayer of the petitioner was made, my lord, in respect of that he has got a special degree, my lord, and he has applied, when he was given, subsequently was terminated, taking a stand that because as per norms fixed by the LCT, your qualification is not up to mark. And because his stand is that he has completed a special degree. Our stand is, my lord, that regulation has further come, my lord, and so far a special degree is concerned.
What is special degree?
My lord, 1 year BA a special degree from the Sanskrit Vidyalaya, Odisha, he has completed.
Okay.
This is the objectionable matter, and that's why it was rejected. And so far our stand is concerned, my lord, that is not. I'm going to fight counter also.
The last occasion, the city was given granted time to file counter affidavit.
If you have to file counter, then why do you start arguing?
No, I have not started because my learned friend is not here, my lord, that's why.
If he's not here, then also we will decide the case. Don't you know that? If the records are here, counsel is not there, then also we can decide.
Briefing, my lord, that's why I'm.
Another
How much time do you need to file a counter?
Only 1 week, 1 or 2 weeks will be given. I will.
in
WPS number
similar matter,
1088 of 2023. The learned counsel for the respondent number 5 prays for and is granted time till 18th of April 2024 by way of last indulgence to file the counter affidavit in terms of order dated 29/1/2024.
My
similar
Post
matter is
on
coming.
24th.
Similar matter is coming on 22. Arising out of
On
same
22nd.
On 22nd. Not
Post on 22nd.
my lord, my name should appear in this.
You file your wakalatnama.
Cause this.
You have to file your wakalatnama.
Item 13 WPS 1174 of 2023 along with item 14.
Death of child. Death of child. Because that is club.
Who is for the respondent? Where is your representation?
Madam,
Murder. Murder.
Where is your representation?
my lordship, in this case, my lord, there are 2 wives, my lordship.
2 wives.
Yes, my lord, on the behalf of the first of my senior Learned Criminal Matters, and I am on behalf of the second wife. The writ petition is, there are 2 writ petitions, serial number 13 and 14.
Okay, 14 is second wife.
And para 12 of the second petition.
Who is the second wife?
I am.
Are you entitled for any relief?
It is true, my lord. I am not entitled. But my lord, I have one daughter, my lord.
Yes, doctor.
I have stated in para 8 of the.
If you have a daughter, then under such circumstances, daughter is not entitled for any post-retirement benefits. She may be entitled for some maintenance from the property of her father under 125.
जो रिटायर बेनिफिट तो
कैसे मिलेगा? मिलता है कभी बेटी को? फैमिली पेंशन बेटी को मिलता है?
मिलता तो है.
What is the age?
बिफोर मैरिज जो है सो मिलता तो है.
एज कितना है?
एज जो अभी जितनी डेट फाइल हुआ तो 12 डेट्स हुई. और यहाँ फैमिली पेंशन है.
अच्छा, this is retirement benefits only. Family pension का तो बात नहीं.
नहीं.
So you claim maintenance. We can't do anything about it. Are you ready to maintain the daughter?
We are not aware about it.
Oh. Death come retirement benefits. इसके लिए तो हम लोग कुछ कर नहीं सकते. You will have to file your maintenance case
तो जो हम मेंटेनेंस के मैंने किनके अगेंस्ट करेंगे जो ये फर्स्ट फैसले तो मिलेगा नहीं.
against the estate of your father.
लेकिन रिटायरल बेनिफिट में तो पिटिशन बीइंग द मदर ऑफ द क्लेम कर सकते हैं कि मेरा बेटी को भी मिलना चाहिए रिटायरल बेनिफिट.
आपको जो क्लेम करना हम लोग यहाँ पे नहीं डिसाइड करेंगे. स्कीम में जो होगा सो मिलेगा, नहीं तो आपको जो रेमेडी होगा लॉ में मिलेगा. वी कांट डू एनीथिंग. द ओनली थिंग वी कैन से इज दैट सिंस यू आर क्लेमिंग सम बेनिफिट फॉर द डॉटर, then you may also be hurt. We do not know how will it ultimately figure out. या तो आप लोग दोनों मिलके कुछ
She
डिसाइड
is also teacher in the high school.
ओ सो आपको तो वैसे भी मेंटेनेंस बेटी को नहीं
हम तो सेकंड वाइफ हम तो क्लेम नहीं लेंगे. हम तो अपने डॉक्टर के लिए तो हम जो
आपको जो क्लेम करना है करिए, इसमें हम लोग कुछ नहीं कर सकते हैं. देखिए दूसरा रिकॉर्ड लीजिए.
तो जो हमको लिबर्टी और स्टेट के खिलाफ में बोल रहे मेंटेनेंस के लिए तो हमको
आपको जो you may have your remedies as per law, but so far as post retirement benefits is concerned, nothing can be paid to you.
लेकिन वो जो इससे पहले जो है मादा में दो वाइफ के बीच में जो है इस तरह का डिस्प्यूट में जो है तो रिटायरल बेनिफिट का हुआ है सेटलमेंट. अगर हम तो और इसमें मुझे हम
लिखिए ऐसे लिखिए.
हुजूर हम इसमें दिखाना चाह रहे थे कि
आपको दोनों को ही सुन के ऑर्डर कर देंगे.
हम
जिसका जो होगा
नोटिस हुआ था. हम नोटिस में अपीयर भी किए हैं. माता नोटिस किया था जो देखा जाए इसमें
कोई बात नहीं, दोनों को सुन के ऑर्डर कर देंगे. राइट? हु विल पास द ऑर्डर? यू टेल अस.
मैनेजिंग
The managing director.
Respond number 2. Right? देखिए WPS number 1174 of 2023 with WPS number 613 of 2023. Learned counsel for the petitioner in both the cases are present. WPS number 1174 of 23 has been filed by MS Seema Kumari, seeking a direction upon the respondents to pay death cum retirement dues of her deceased husband, namely Manoranjan Prasad Singh. The counsel for the petitioner has submitted that Manoranjan Prasad Singh expired on 29/4/2020. While he was in service. He also submits that other benefits have also been claimed by the petitioner, which was payable to ex-employee. The learned counsel has submitted that the petitioner has represented before the respond number 2, but no order has been passed, and therefore the present petition has been filed. 25/2 को फाइल किए हैं और 1/3 को यहाँ पर रिट पिटिशन. इतना स्पीड में तो कोई कोर्ट नहीं चलता. 4 दिन के अंदर. यस. So far as WPS number 613 of 2023 is concerned, the same has been filed by Kiran Kumari Saw, who also claims to be the wife of the ex-employee, namely Manoranjan Prasad Singh. It is submitted by the learned counsel appearing on behalf of the petitioner in WPS number 613 of 23 that the petitioner also has a minor daughter, and he submits that even if the he also submits that the claim of minor daughter who is a school-going child cannot be denied under any circumstances. Even if the petitioner is the second wife of the deceased, Manoranjan Prasad Singh. Okay? He has also submitted that the respondent Mineral Area Development Authority has also passed certain orders wherein children born out of second marriage have been given some benefit arising out of post-death benefits. However, no such order has been annexed along with the writ petition. Correct? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court is of the considered view that the grievance of the petitioners and any claim of any child petitioners and their children with regard to post-death benefits is required to be considered at the first instance by the respondent number 1, who has to take into consideration the facts of the case as per the applicable scheme and also consider if any relief can be granted to the minor daughter of ex-employee born out of second marriage. He has also to examine as to whether any such relief has been granted to similarly situated persons in the past. When the case is taken up today, neither anybody is appearing on behalf of the respondents, nor any counter-affidavit has been filed. However, considering the nature of relief and the fact that no adverse order has been passed in the case, and also the fact that the petitioner of WPS number 613 of 2023 was issued a notice dated 19/11/2022 as contained in Annexure 6/1 to appear before the Secretary respondent number Secretary of Jharkhand Mineral Area Development Authority, who was also examining the claim of Seema Kumari, the petitioner of WPS number 1174 of 2023. This court finds that the Secretary of MADA has already issued notice to Kiran Kumari Sao for consideration of her claim, and Seema Kumari has also lodged her claim before the said authority. The Secretary of MADA is directed to grant an opportunity of hearing to both these writ petitioners and pass appropriate order in connection with their entitlement and stroke or entitlement of children born to them. The needful be done by the respondent number. ये secretary के पास ही भेज देते हैं.
जो decide करेंगे ये करेंगे chairman का managing
The needful be the appropriate decision be taken by the respondent number 1 after granting an opportunity of hearing to both the parties. To both the writ petitioners within a period of 2 months from the date of communication of this order, from the date of communication of this order to be filed by the petitioners before the said authority along with a copy of the writ records. It is for the respondent number 1 to verify the facts and claim of the parties and pass appropriate orders in accordance with applicable guidelines, rules, etc., which may be applicable to the parties. These writ petitions are accordingly disposed of.
उसको क्या chairman का managing director of MADA कर दिया.
हम कर देंगे. हम जब करेक्शन करेंगे तो इस चीज़ का ध्यान रखते हैं.
वहाँ चेयरमैन नहीं होता, सिर्फ मैनेजिंग डायरेक्टर होता है.
Managing Director of MADA, right? Post